about when it's really not an afterthought. So I have a lot of concerns about how this is being handled, and this is, again, like the third or fourth time they've done this. And this can't keep happening. I have to state that for the record. So, and again, Fackelman doesn't apply here. Fackelman's not. That's a confrontation clause issue. This isn't a confrontation clause issue. So I'm going to state that for the record right now.
Okay.
If I may be allowed to retort, Your Honor, first of all, as you know, the motion, there was a supplemental motion to motion eliminate number 3, February 1, 2021, where we addressed the 703 issue. And as to this idea of late motion, as soon as they filed their exhibits saying that Ballier was going to testify in their report and the towels, we filed an objection citing that. So this is completely timely. Now, as to the substance, Fackelman doesn't just deal with the confrontation clause. Fackelman is a Supreme Court case from 2011, 489 Mich 515, 2011, and the page that I would cite you to is 535. It says there are other reasons why the use of Dr. Shahid's report at the defendant's trial was improper, and it cites MRE 703. Then the court goes on to state, because the facts and data in Dr. Shahid's report were essential to the testifying expert's opinions, they were required to have been admitted into evidence under Rule 703. In this case, Dr. Ballier is going to say, I don't remember the case, but he is going to read from, they want him to read from a report or testify that it tested positive. There is no underlying data. As Mr. Ernst will testify, there are charts. The experts have to interpret the data to get a result.
We're going to argue this motion when this witness is here, and I can hear what he's an offer of proof, basically, as to what his anticipated testimony
is spot on.
Okay. Anything else, Mr. Blair?
Your Honor, I don't want to obviously litigate this right now. I don't think the court wants to hear it, so we'll have to litigate this at the time. But I think the defense is misinterpreting what Fackelman states. Okay. So that's all. I'll leave it with that for the court right now.
And I will state for the record that the defense has had years, not months, not weeks, but years to raise issues with the court. And then in the last 3 weeks, a flurry of motions have come before the court, apparently not recognizing that I also have other trials to take care of, and the prosecution has the right to a fair response to motions that are filed. I've done the best that I can to make time for thoughtful and well-researched and well-reasoned opinions, but it gets difficult for everybody. It's too late to remedy it now, but it's just for the record. Ready to call another one? Oh, we're still missing 3 jurors. So we'll take a quick. Okay, thank you. witnesses that are coming on, and just leave it at that?
Yeah, and then I think then what we said is then, and maybe after all the proofs have come in, to then just let them know that some of the items on the list are, you've made a ruling that are not, we can't give. Because I do believe on that list they asked for a police report.
Yeah.
Am I remembering that correctly?
Yeah, copies of police reports, copy of fire report.
Right.
Okay.
So maybe Jen, we just make then a more general ruling now, and then later, you rule that some of these are not admissible. How.
Or I could just say that, I could just say now, some of the things you're asking for are not admissible. But lawyers have been advised of your questions, and you may get answers to some of them later. Something.
That's perfect.
Is that suitable to defense?
Yes,
Okay. Anything else before I bring in the jury?
No, Your Honor.
Okay. We'll have the prosecutor call her next witness, but I did receive a series of questions from the jury at the end of the day yesterday. Some of the things that are being requested are simply not admissible under the law, so I've determined under the law not to provide. I have provided the questions to the attorneys, and I think they're indicating that some questions may be answered with upcoming witnesses. Counsel, is that a satisfactory response?
Yes, Your Honor.
Okay, thank you. Ms. Zyderby, you may call your next witness.
Thank you, Your Honor. People call Kim Thompson to the stand.
Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. And you can move the microphone close to your mouth so the jury can hear you. And if you could start by telling us your full name and spelling your last, please.
Okay, my name is Kim Jean Thompson, Thompson.
Thank you, Ms. Zyderby.
Thank you. Ms. Thompson, did you know Todd Stermer?
Yes,
How did you know him?
as a friend and a neighbor. He was also my daughter's softball coach.
How close was your home to his home?
Oh, approximately 2 miles, 2.5 miles.
And did you know Linda Stermer?
Yes.
And how did you know her?
Through our children, we also shared a love of chocolate labs and horses.
And when did you know the Stermers in 2007?
Yes,
And did you become aware of a fire that happened at their home?
yes.
How did you become aware of that?
My cousin heard it on the scanner, and she knew that we were friends with Todd and Linda, and she got a hold of us and said that there was a fire, and so we immediately ran over to provide comfort to both of them, thinking that it was their fire of their home.
So when you got there, do you recall if there was anyone else there at the time?
There was the fire chief, Stephen Leach. I believe the assistant chief at the time was Doug Harrington, and he was there. and one of the fire department vehicles was there, and the only other ones that we saw were Mathany's, Mike, but I was focused on Linda.
So were you able to drive down the driveway, or how did you get to the house?
We didn't want to impede any of the rescue vehicles, so we parked our truck along the road on the opposite, or near the driveway, but not in the driveway. We didn't want to impede rescue vehicles.
Because at the time, were there any fire trucks there?
There was just one at that point in time, and after we got there, then, I mean, they came rolling in.
And were you able to then make contact with anybody to approach the house?
The only ones we saw at that point in time were Doug Harrington, and then I saw Linda, and I just immediately went to her.
So you just ran down the driveway?
Yes.
Okay.
Yes.
And so where did you first see Linda at?
On the hill to the north side of the house, near where Todd was laying, and at that point they were still trying to administer first aid, and so I just ran to her and wrapped her in my arms.
And were you able to speak to her at that time?
Very little. We were all so emotional at that point. I was just trying to provide comfort at that point.
And who was with you? Who came with you to the house?
My husband was with me, and then also my cousin Annette, who was there as well.
And then what did your husband do?
I believe he went to where Todd was, and he came back immediately, and he said, "Do not go near there." The dogs were, like I said, we had a love of dogs, and one of their dogs was actually one of my dogs that I raised and train to breed, and so the dogs were trying to jump. One of the dogs was trying to jump back into the house, and so my husband was trying to corral the dogs. Coco came right to me because, like I said, she used to be mine, so she ran right to me, and so we were able to keep her safe. But then my husband was trying to get the other one.
So there were two dogs?
Yes.
Do you recall what Linda was wearing at that time?
No, I don't remember the specific clothes. I know that it was for a January day. It was actually very pleasant. It started out that way. And then it kind of started to get a little less pleasant. And one of the firefighters, and I don't remember if it was Chief Leach or who it was, brought a blanket. And so she had the blanket wrapped around her.
Did you notice if she had anything on her feet?
I did notice that she did not have anything on her feet. She was in her stocking feet.
And did you do anything to help with providing anything for her feet?
Yes, because especially when it started to get sleety and rainy, I was worried that her feet would get cold, and so I asked her what size shoes she wore, and she told me, and I knew that one of my aunts wore a 9 narrow, and so I let my cousin Annette know, who then contacted her mother and gathered up clothes and things for her and shoes so that she would have something on her feet.
And did they ultimately bring those clothes and shoes to the scene?
Yes.
And were you there then when Linda was able to change into those clothes and
Yes.
shoes? Where were you when she was changing into those clothes?
I was, I believe she put the shoes on right away, but then when she changed clothes, one of the, I don't remember if it was a rescue or if it was a police officer, but they had her go into like a van, and she changed clothes in that.
And did you see what they did with the clothes?
I just saw them put them in a bag.
How long did you stay on scene?
Quite a while. Like I said, I mean, she had no one else there with her from the family, and I knew that she needed somebody. I couldn't imagine going through that alone.
Did you stay into the evening hours?
I believe I stayed until she did have someone come, one of her family members, I believe. I don't know for sure who it was, but then they did take her, and then we left the scene.
Did she talk to you at all about what had happened that day while you were on scene?
No, she was very emotional, and then I think about the only thing she did ask was when things were, I guess, wrapping up and she was getting ready to go. You know, her concern was, would you take the dogs? Would you take care of the dogs for me? And we said, of course.
So you ended up.
So we took the dogs with us, and we took care of them until they went back to family.
So did you have an opportunity to talk with Linda after the fire?
Yes. She came to the house a few times, and we sat at our kitchen table, and we were just trying to all make sense of what had happened. And so yes, she did come a few times, to check on the dogs, and then also, we were friends, and so came and we had been there, and so yeah, we did share a few times.
Did you ever ask her about what had happened?
Yes.
And do you remember what she told you when you first asked her?
I don't remember the order of what we were told, but it did change each time. And one time it was, he had a cold, and she had given him some Benadryl, and she thought that maybe he was drowsy or sleeping from that, and that when whatever happened, he couldn't get out.
Did she say where he was?
In his chair in the living room.
Did she say where she was?
She said she was in the basement.
Did she say what she was doing?
I believe she said she was doing laundry.
And then did she tell you how she, or why, or if she went upstairs?
She said she heard something, and she ran up the stairs and saw that there was a fire, and she couldn't get up. And so then she went out the walkout basement door and ran around to the van to try to get help.
Did she say she ever saw Todd before she ran out the basement door?
At that point, no. Later, she did say that she did see him, and that he ran out as she was trying to drive the van to go get help, and that was all. Just that she saw him when she was in the van trying to get help.
So that was at a later date?
Correct.
That she said she saw him outside?
Correct.
And you said that as you talked to her then, the story changed a little bit?
Yes.
Do you recall then the next version, or what the next thing she told you?
One of the other things she had said was that he was smoking pot, and she thinks that he caught himself on fire.
Did you ever know Todd to smoke pot?
I didn't know.
Did she ever talk to you about anything about heating with kerosene?
Yes, we knew that they heated with kerosene as they were building the home. They had a kerosene portable heater in the living room, and that they would fill the kerosene heater there.
Did she say that the kerosene heater was being used that day?
I don't recall.
At one point when you were helping with the dogs, did you see the van?
Yes.
And tell me about when you saw the van.
We were trying, Coco was under control, the chocolate lab, and we were trying to get control of the other dog. And he kept trying to get back in the house. And so we were really worried that he would do that and get hurt or injured or killed. So my husband and I kind of tried to corral him, and he ran around to the walkout level. And when we ran down there after the dog, I saw the van door open. The van was running, and I observed what looked like blood on the front fender and I believe bumper, but definitely on the fender. And I remember my husband and I looked at each other, and we both said the same thing: something's not right.
Could you tell if the van was running at that time?
Yes, it was running.
Did you ever ask her about the van?
No.
Did you ever tell her what you saw?
No.
Did she ever tell you anything about the van?
No. Other than at the beginning, she said she was in the van to get home.
When you were there on scene, did you see any smoke or flames?
Yes. When we got there, there was smoke coming out of the lower windows, and it was shocking to me how quickly even with fire department there, how quickly the home was within. It seemed like within a minute and a half, there were flames coming out of the roof. It was so fast. It was shocking.
So when you got there, it was just more smoke?
Correct. We could see a little bit of flame in the front lower level windows, but we didn't see any smoke or flames coming out of the upper story until, like I said, it was a very, very short period of time, and then there's smoke and flames everywhere.
So I want to just be clear, there's the walkout level.
Correct.
There's the main level,
Right.
and then there's a second story, correct?
Correct.
So when you say when you first got there and you saw the smoke, you're talking about the main level?
The main level, as we were coming up the driveway, it's an inclined driveway, and as we got closer up on top of the hill, we observed the smoke coming out of those windows. The main level front windows, roadside windows.
Did you ever talk to Linda about where the boys were?
Yes, that was our first concern. Where are the children? And we asked that, immediately when we first saw her. Where are the children? And she said the children were safe. They were gone. I think she said they were in Kalamazoo, but she did say that the children were safe because we were very, very concerned that they might still be in the home.
Did she say why they went to Kalamazoo?
No.
When you saw the van, how close was it to the back of the house?
I would say within 5-6 feet of the little walkout door.
Were you ever interviewed that day by police officers on scene?
No, we got there before the police officers were there, and then what we later found as we left, that there were police stationed at the base of the driveway taking the names of everybody, but we didn't realize that was going on, I didn't realize that was going on. So we never, as far as I know, we were never on that list because we were there before that took place.
And then when you left, you just left.
Right.
Is it safe to say that was a pretty chaotic scene that day?
Very, very, very traumatic and emotional, yes.
And do you see Linda Stermer in the courtroom today?
Yes.
Yep. Could you point to her and describe her by something she's wearing?
Ms. Stermer is the person that she knows that was there on January 7th.
Thank you, Your Honor. I have no further questions. Thank you very much.
Okay, thank you.
Mr. Kelly?
Good morning, Ms. Thompson. How long had you known the Stermers?
Oh, since before they built their home, the children were young and in Little League together, and Todd was a coach. And I think Linda and I bonded initially with her 2 chocolate labs. I was a chocolate lab lover as well. So we just kind of bonded, I think, over our children and our dogs. And we both are horse lovers and both had horses. And so we bonded over those things. And they were a neighbor. And in our area, neighbors look out for each other.
Okay. And so, in reference to the home that was destroyed by the fire, was there another home that they lived in the area that you knew at that time as far as the relationship?
I knew they lived in the area because our children went to school together at that point in time before they were in Little League together, and Todd was our daughter's coach. I don't recall where exactly they lived prior to that home. I know where Linda lived after the fire, but I don't recall where they lived before that. I know at one point they lived in Lawrence, kind of across the road from Sills Bar Market, but I don't know if that predated the home or while they were building the home or if it was after.
So they lived in Lawrence
Yes.
before they built the house that was destroyed in Lawrence, is that right?
That's my understanding, yes.
Okay. But you never went to that home?
Not that I recall.
Okay. And so the relationship that initiated with you and Ms. Stermer was a result of the children and the love for your horses and your dogs, is that correct?
Correct.
Okay. Did y'all participate in any type of competition with the horses or the dogs?
No. She did assist us, me, in when I was establishing my breeding operation for the chocolate labs. She did help facilitate finding the stud dog that I used, and so, like I say, it was a mutual love. They bought one of our puppies, and then later Coco, which was the second dog that they got from me. So it was, I guess, like all I could say is that we had a mutual love of dogs and horses and kids.
So that the horses that y'all used, did y'all raise horses for sale or were they for competition?
My horses were just for pleasure riding. At that point, Linda had rescued some horses too from out of state, I believe, and so they were caretakers for those horses, those rescue horses.
Okay. So over the years, how many years would you say that you had known the Stermers?
Oh, that's difficult. I would say 3 years possibly before the fire.
Okay. And so this unfortunate incident occurred in 2007. Were you contacted by any law enforcement agency after the fire to give any type of report or interview?
No.
So in 2007, did you make any attempt to contact anyone in reference to any information you had about what you saw that day?
No.
Have you ever been contacted by the Van Buren County Sheriff's Office?
Just recently.
And when you say recently, how recent is that?
Possibly, I don't know the exact date. It was before we left for Florida for the winter.
In 2024, 2025?
24,
2024.
correct.
So from 2007 to 2024, you had never been contacted by anyone from the Van Buren County Sheriff's Office or the State Police Department for the state of Michigan or the State Fire Department or any law enforcement officer. Is that
No.
correct? Is that correct?
That is correct.
Were you a little surprised when you were contacted in 2024 for an incident that happened in 2007?
No,
You wasn't surprised?
no.
Ms. Thompson, had you ever seen a house fire before?
No.
Okay. You mentioned the fact that you were aware that kerosene was on the property as part of the household use of heat. Is that correct?
Yes.
Did you ever visit the home to see the location of their heating system or how it was installed?
The only time I saw the kerosene heater was during construction when they were in the process of building the home. And it was in the lower level as you walked in. It was like kind of like right there in the open area when it was under construction.
Were you aware of how much kerosene was used on the, as far as the heating system in the house?
No.
Okay. Do you ever see any gasoline on the property?
It was a farm. We all have gasoline on our farms.
Okay. You ever see any of the machinery that they had on the property?
Tractors,
How many?
lawnmowers.
Okay. Now, you don't know what caused the fire.
No,
Okay. And when you arrived at the scene, your cousin is Annette Grandel? Is that
Correct.
right? Is that right?
correct.
Okay. And the reason why you came to the location, was it because you got a telephone call from Miss Grant, your cousin?
Correct.
Is that correct?
That is correct.
And did you and her meet there together?
Yes.
You did? Okay. And where was Linda when you arrived at the house?
She was on the hill to the north of the house, a short distance away from where they were working on Todd.
Okay. And when you say the hill, are you referring to the elevation of the house, and there's an upper and a lower?
There's an incline, what I would call a small hill, going from the road level up to where the home was built, and it was built on a hill. It was a walkout, so it was at where the home was, and to the north or to the right of that. And Linda was a little, probably a short distance away from that while they were administering aid to Todd.
Okay. And you stated that there was Mr. Steve Leach was there, right?
Correct. He was the one, I believe, that was working on Todd.
Okay. And do you recall anyone else being present?
Doug Harrington, who I believe was the assistant chief at the time, and I believe Mike Matheny was standing off to the south side, but I didn't talk with Mr. Matheny.
And who was Mr. Harrington?
Doug Harrington was our township supervisor at the time, and also I think at that point in time he was also the assistant fire chief.
Did you observe Mr. Matheny providing any assistance and aid?
I didn't notice. Like I said, I was focused on Linda and went immediately to her.
Okay, and where was she? Was she inside one of the vehicles, or was she standing outside?
She was standing outside at that point in time.
Okay. Did you observe her at some point being placed in a vehicle?
Yes. My cousin Annette's mother, my Aunt Gail Crandall, arrived on scene with the clothes and the shoes, and then she sat inside. I believe it was Chief Leach's personal vehicle, a red truck. My aunt and Linda went into the truck together.
Was there an ambulance there at the time that you were present?
Eventually, but not when I first arrived.
Okay. Well, did you see Ms. Stermer? Did she leave while you was present?
Yes.
Okay. How did she leave?
I believe it was a family member that came and got her. I don't recall exactly who it was.
Okay. Did you observe any law enforcement officers talking to Ms. Stermer?
Yes.
Do you know who it was?
No.
Okay. Was it a male or a female? Do you recall?
Both.
Okay. How far was your house from the Stermer's house?
About 2.5 miles.
Okay. Could you see the smoke from your house?
No, our home is in the middle of the woods.
Okay. But as you approached the premises, you made a statement that you could see a lot of smoke?
Yes.
Okay. From the upper part of the house, right?
No, initially when I arrived, the smoke was coming out of the lower windows on the roadside on the main level. And we were there just a very short time, and smoke started coming out of the upper story windows and then out of the roof.
So when you first arrived, you saw smoke coming from the lower part of the house?
The windows on the main level on the roadside.
On the road side, is that what you're saying?
Correct. So not the walkout side, but the main level side.
Okay.
What I guess you would call the first story, not the basement.
Okay. Do you recall what the weather conditions was as far as the terrain there that day?
It started out as a sunny winter day. It was unseasonably warm initially. Then the weather did deteriorate, and it started spitting like a rain-sleet mix. And that's when I noticed that she was in her socks, and I was concerned, about that.
Okay. She was outside in her socks without a coat on, is that correct?
Correct.
Have you been shown any photos of the property or of the house?
No, I was not shown any photos.
Okay. And you retrieved the two dogs that was at the property, is that right?
Correct.
Okay. Were there horses still on the premises at that time?
Yes, in the pasture.
Okay. Did you help care for those and rescue the horses?
Pardon?
Did you have anything to do with the relocation of the horses, or did they remain there?
I did not.
Okay. I have no further questions, Your Honor.
Thank you. Ms. Eisen? I have no further questions, Your Honor.
Jury, any questions of her? I've got some hands going up. If you haven't already done so, we'll have you write them down and we'll retrieve them. Okay, I'm asking some of the questions asked by the jury. I'm not asking others, determining under the law not to ask them. What time did you arrive on the Stermer scene?
I believe it was the early or mid-afternoon.
You observed blood on the fender, you testified. Where on the fender?
On the front bumper on the driver's side and on the fender of the front driver's side.
Okay. Okay, thank you, counsel. Any questions in light of those questions and answers?
No, Your Honor.
Any questions in light of that question and answer?
Just
Okay.
Ms. Thompson, when you say you saw blood on the fender, on the driver's side?
On the front of the vehicle. And I believe it was on the front quarter. I don't know the terminology, but like the front on the driver's side and on the side of the driver's side is where I observed blood. There might have been blood elsewhere, but I don't know. That was the only location that I saw, and then I backed right off when I saw that.
But you've never been shown any pictures
No.
for you to point out
No.
if that was correct as to what you saw, right?
That was just what I observed, and I saw that location, and my husband and I looked at each other, and we both said something's not right, and I backed right off. I did not want to be there, so we got the dog and we got out.
I have no further questions, Sean.
No further questions, Your Honor.
Jury, any other questions of her? Nope. Is she excused from her subpoena,
I
counsel?
would ask that she please be excused.
Mr. Kelly, agree?
Yes, Your Honor.
Thank you. You're all done. Thank you. Thank you. Ms. Siderby?
Thank you, Your Honor. People call Ken Thompson to the stand, please.
Sir, before you have a seat, I'll have you raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Please have a seat, sir. You can move that microphone close to your mouth so the jury can hear you. And once you're settled, we'll have you give us your full name and spell the last, please.
Ken Thompson, Thompson.
Thank you. Ms. Siderby?
Thank you, Your Honor. Good morning, Mr. Thompson.
Good morning.
Mr. Thompson, did you know Todd Stermer?
I did.
And how did you know Todd?
He coached my children, and he was a neighbor.
And how well did you know him?
Oh, I thought fairly well.
And do you know Linda Stermer?
Yes.
And then how do you know her?
The same. Yeah. And just a neighbor and someone in the neighborhood and the mother of children that my children grew up with.
And how close is your house to the Stermer residence?
Oh, as a crow flies, about 1.5 miles by road, maybe 2 miles.
Do you remember January 7th of 2007?
I do.
And could you tell me what you were doing that day?
We spent the day on the farm across the road from Stermer's cutting firewood.
What was the weather like?
It was a beautiful day. It was shirt sleeve weather until later in the afternoon. It got nasty.
And so when you say you were across the street from the Stermers, were you directly across the street from the Stermer residence?
Just on the farm across the street, but at the north end of that farm.
And do you recall when you saw the fire?
It was, I went by Stermer's, went home, and I was probably home 15, 20 minutes, and we got a call that Stermer's house was on fire.
So you had just driven by the Stermer residence 15
Yes.
or 20 minutes prior?
Yes.
And then how did you learn that there was a fire?
Kim's cousin Annette called, and she heard it on the scanner.
And so do you remember distinctly seeing the Stermer home as you were passing by it?
I can't say that. I didn't notice anything out of the ordinary.
You didn't see any smoke.
No.
So what happened then once you got that phone call?
I told Kim to jump in the truck, and we headed right over there.
And what was your thought? What were you going to do?
Anything we could.
When you got there, was there anyone else there?
I saw Chief Leach was there in his pickup truck, and I saw Mike Matheny in his pickup truck.
How long would you say it took you from the time you got that call on the scanner to get to the Stermer residence?
5 minutes maybe.
So you had just been by 15, 20 minutes prior, walked in the door, got the call, and then it took you another 5 minutes to get back over there.
Correct.
Did you go up the driveway, or where did you park your car?
We parked out toward the road so we wouldn't hinder any, because I knew fire vehicles would be coming. So we parked out by the road, and then I headed up the driveway to the house.
What did you do then once you got down the driveway?
I saw Linda, and I asked Linda, where are the children? Is there anybody else in the house?
And what did she say?
At first she was kind of incoherent, and my first thought was for the children in the house, so I was headed for the front door when she stopped me and said, no, there's nobody in there. The children are somewhere.
So you were getting ready to go into the
I
house?
was.
And did she come up to you and stop you, or did she grab you, or how did that?
Well, no, she just, I went by her, headed for the house, and she stopped me, just called to me.
And then what did she say at that point?
She said that there was nobody there, the children were somewhere, and I don't remember where she said they were.
Did you see any smoke or fire at that time?
I did, just a very little bit coming out of the chimney chase, the very top of the house.
At the top of the house?
Yes.
And that was the only place you saw smoke at that time?
Yes.
There were no firefighters there at that time?
Just Chief Leach was there in his personal pickup truck.
So you didn't see any smoke coming out the windows at that time?
Not at that time.
And you were standing in front of the house?
Yes.
Having this conversation with Linda?
Yes.
Did you see Todd at all?
Not that I recognized this Todd.
So tell me what you saw.
Well, I saw Chief Leach on the ground working on something, and I didn't recognize as a person.
Did you go over there?
I went too close. I wish I never would have.
What'd you see?
It was unrecognizable as a person.
Couldn't recognize his face? Couldn't recognize his face?
No.
How close did you get to Todd?
Oh, I would say from me to you.
Can we get a reference for the record? I'm going to say 12 feet.
I think yesterday we said 16, but I'll go with 12 today.
Sharpen my eyes a little bit.
And I understand this is very difficult. Where was Linda at that time?
I think she was still in approximately the same spot in the driveway in front of the house.
In front of the house?
Yeah.
What was she doing?
Oh, I kind of lost track of her at that point.
What did you do then? You said you lost track. What were you
Then
focusing
the
on?
firefighters started to arrive, and you know, I know all those guys, and I just went to them and see if I could assist them in any way, ladders, hoses, whatever.
And were you able to assist them?
Well, not with ladders or hoses. Yeah.
So how long were you on scene?
5 hours.
And you said when you got there, you just saw a little bit of smoke coming out of the top of the house?
Yes.
What did you observe then in the minutes that you were there?
Smoke started coming out windows, and you know, eventually the whole house went into cold.
How long did that take, do you think?
Yeah, I don't remember exactly, but it, you know, probably 20 minutes, half hour.
So it was minutes.
Yes.
After the fire, did you have conversations with Linda, or were you present when she was talking about the fire?
Yes.
And where did those conversations happen?
Our kitchen table.
And do you recall what Linda said happened that day when she was at your kitchen table?
No.
Did she tell you where she was when the fire started?
Well, she told me that, you know, I talked to her the evening of the fire.
Oh,
And she said she was in the basement doing laundry.
So this was actually the day of the fire?
Yes.
Not at your kitchen table?
Right.
So then, was this a few hours after you arrived, or was it close to the time you arrived?
Close to the time.
Okay. So what did she tell you when you were talking on scene about the fire?
She said that she was downstairs doing laundry, and Todd was sleeping in his chair, and Todd yelled, "Linda, get out, the house is on fire." And she went out the basement door.
And she went out the basement door?
She said she looked up the stairwell and could see she couldn't get up there.
Did she say why she couldn't get up there?
I think there was flames or whatever, the impression I got.
And then she went out the basement door?
Yes.
Did she say anything else about that day?
Yeah, we talked for, you know, several minutes, several times. And I don't remember every bit of the conversation.
Anything that you remember about the fire and conversations with her, or just that?
Pretty much that.
And you stayed on scene for several hours.
Yes.
Did you stay until Linda left?
What's that?
Did you stay until Linda left?
I'm not sure. I know Linda was with the girls and I was with the firefighters, and I kind of lost track of her.
And at some point, did you see the van on the property?
I did.
And tell me why you saw the van.
Well, the deputy had asked us to guard that van and make sure that nobody touched it, or especially nobody sprayed it with water.
And why was that?
I guess there was evidence on it. You could see blood on it.
So you saw the blood?
I sure did.
And where did you see the blood?
Oh, down the front of the van, and then on the bumper going underneath the van.
Have you talked to Linda? You said there were some conversations at your kitchen table after the fire.
Mm-hmm.
Did you have any conversations with her about the fire at your kitchen table?
I don't recall.
I have no further questions for this witness, Your Honor. Thank you.
Thank you, Your Honor.
Morning, Mr. Thompson.
Good morning.
I think I can segue some of the information I previously received from your wife. You and your wife have known the Stermer family for about 3 years prior to the date of the fire. Is that correct?
Yeah, ever since they moved to Lawrence.
Okay.
Yeah.
Okay. Did you ever go over and participate with Mr. Stermer in reference to any of the construction of the house?
Not the construction, no.
Okay. Did you ever go over to the house while the house was under construction?
Yeah, probably a time or two.
Time or two?
Yeah.
Okay. Could you describe what you knew as far as the layout of the house?
No. No, I didn't know the layout of the house.
Didn't?
I never went inside.
Never went inside? Okay. Okay. What would have been your purpose for being over to just...
Todd had a business. He sold military surplus, and I purchased a lot of things from him.
Military surplus?
Yes.
Okay.
Clothing. Yeah.
Okay. So he had an office that he worked out of the house with. Is that right?
I'm not sure. No, he always had stuff in his truck, or he would just bring stuff out.
From the van? Or?
I don't remember the van.
Okay. Okay. Would it be fair to say that your knowledge of a fire was from a telephone call of your wife's cousin about the reason why y'all came to the house?
Yes, that's why we went over there.
Okay.
Yes. The call was, Stermer's house is on fire, and I thought, I just went by there. Stermer's house isn't on fire, but so we hopped in the truck and headed right over there.
Okay. So now that brings me to a question that you stated that you had just been by the Stermer house.
Yes.
This was on a Sunday. Is that correct?
It was on a weekend. I know we were cutting firewood across the street. It might have been Sunday.
Okay. And about what time of day was it when you had been by the house?
Oh gosh, we'd cut firewood for quite a long time. I'm not sure. Maybe sometime in the early afternoon.
Okay. And when you say you was cutting firewood, are you cutting firewood across from the Stermer property?
Yes. Yes. On the neighboring farm, right across the road.
Okay. You and who else?
Me and my two cousins.
Okay. And what time did y'all start cutting firewood?
Well, probably 9 a.m.
Okay. Did you know the vehicles that was part of the family that was parked at the Stermer property?
No.
I mean, had you seen... Well, let me just clarify that. Did you know how many vehicles that the Stermers had?
No.
From the times that you had been over there, you only saw one vehicle?
You know, over the years, differing vehicles at differing times.
Okay. Well, let's say for, just during this period of time when you were cutting firewood, say for instance the last 2 weeks prior to that, had you seen the vehicles, any vehicles at that property?
No, not that I noticed, no.
Let me ask you this, had you ever seen the van?
I didn't remember that van until that day.
Okay. Could you say what type of vehicle you had a memory of that you had seen there on the property?
No.
you stated that Mr. Stermer sold you some products or
Yes.
from his truck?
Yes, it seemed like he had like a cube truck with a roll door on it at some point.
Okay.
Yeah.
Okay. Okay. Now, so you all complete your task of cutting wood about 12 o'clock that afternoon?
No. It was later in the afternoon. It was I would guess in the area of 4, maybe 5.
4 or 5 o'clock?
Yeah, I think so. Yeah.
And so you had a direct view of the Stermer property from where you all were cutting wood, right?
No, we were at the north end of that farm, and there's trees and fence rows, and no, I couldn't see their house from where we were.
Okay, but when you finish cutting your wood, you're leaving, you have to come on the road.
Right.
And pass
We
the
went by
Stermer property.
Stermer's house, yes, on
Okay.
the way home, yes.
Okay.
And I didn't notice any smoke or anything out of the ordinary.
And didn't notice any vehicles there, is that right? Of course, you wasn't looking for
I
anything
wasn't.
suspect,
I
right?
I was not.
Okay.
No, we were headed home.
But you definitely didn't see any smoke or any fire?
I didn't notice anything out of the ordinary.
Okay, okay. Did you notice anybody outside at all?
I didn't.
Okay, all right. What was the weather conditions that day that you recall?
It was earlier in the day. It was just beautiful. It was a perfect day to cut firewood. I mean, we were in flannel shirts, and it was the weather was good. But later in the afternoon, around dark, the weather got pretty bad. It was spitting snow and rain, and it got pretty rough.
Okay. And the road that is in front of the house, the Stermer property, is it paved or
It is.
gravel?
Yes, County Road 215. It's paved.
It's paved.
Yes.
Blacktop or paved?
Yes.
Okay. To your knowledge, on the Stermer property, when you turn off the road for what would be, or driveway, was it paved?
No. It's gravel.
Gravel?
Yeah.
Okay. And have you ever been to the backside of the Stermer property?
Well, before they
Before
built
the-
the house, I knew every step of that property.
I beg your pardon, you said before you...
Before they built the house, yeah, I was on that property quite a bit.
Okay, so you knew the property before they even purchased
Yes.
the property?
Yes.
Okay. What was do you know how many acres it was?
Well, it started out, it was the original farm, it was a big property, and I'm not sure how many acres that they purchased.
Okay.
Yes.
But you was very familiar with the geographical layout of
Yes.
the property, right? And the house itself, could you describe the sloping of the house? Was it flat or was it an incline?
No, on the sides of the house, it sloped down, with a walkout basement.
Okay.
I would say that it was about a one-story drop from, the sides of the house down to the basement entrance.
Okay. And so when you arrived on the property as a result of the telephone call from your wife's cousin, you stated that you immediately saw smoke from the chimney?
Yes.
Okay. Did you see any flames from the chimney?
No.
But you saw smoke?
Yes.
Was it a large ball of smoke?
No. I thought that initially that it was a chimney fire because it was the smoke was coming right out the chimney chase, and that's the only smoke that I saw. So I thought maybe they just had a chimney fire.
Were you familiar with chimney fires?
Yes.
Have you ever served on the fire department before?
No,
Okay. But you've seen a chimney fire before?
many.
Okay. Were there, could you give an estimate time frame as to, if you can recall, when you and your wife arrived? What would you say a guesstimation of your time when you arrived
When we
on
arrived.
the property?
I'm not sure.
You left cutting the wood
Yes.
about 3 or 4?
Yeah, 3, 4, 5, somewhere in there.
Okay.
Yeah.
So you say it was after 5 o'clock then, right? When you would arrived at the Stermer's property?
That I couldn't say. I didn't look at a watch.
Okay. And did you pull into the property off of the road?
Yes, we pulled just off the road, and then, like I say, we wanted to make sure that we weren't going to hinder any fire vehicles, so we kind of got out of the way. We made sure our vehicles were out of the way.
Okay. And by the time that you're parking your vehicle, you begin to see smoke coming from another part of the house?
Well, it didn't take very long, and then there was smoke coming out windows.
Okay. And you saw that after you
Yes.
got out of your vehicle, is that right?
Right.
Okay. And these windows, they face the frontage of the road, is that right?
And on the sides.
And on the sides? Okay.
But I noticed the smoke coming out the windows on the side.
Okay. But you didn't see any fire trucks there at that time? Right?
No, just Chief Leach was there with the chief's truck.
Okay. So what did you do when you saw the smoke coming out of the windows, you see the smoke coming out of the chimney, you and your wife get out of your vehicle? What do you do then?
Well, I saw Linda in the driveway, and I quickly went to Linda. I was concerned for the children, and I said, "Linda, where's the children?" And at first she was kind of incoherent, and I thought that the children would be inside. So I was kind of headed for the door, and she said, "No, there's nobody in there. The children." I forget where she said they were.
Okay, when you saw Miss Stermer, was she with somebody else? Or
No,
was
she was
just
by
standing
herself.
there by herself?
She was by herself.
And where were, you said Mr. Leach was there, where was he at?
He was just to the north of the driveway, and he was on the ground.
Okay.
And at first I thought maybe he was working on some equipment, a fire extinguisher or whatever. I didn't recognize that it was a body.
Okay. And did you see anyone else there?
No.
Just Mr. Leach and Miss
Right.
Stermer?
Right.
Is that right?
Yes.
Okay. And so after you were comfortable with the fact that there was no one else in the house, the children wasn't in the house, nobody else was in the house, what did you do then?
Oh, I just waited for the fire department to arrive. And it wasn't very long, and they arrived.
Okay. And do you know which fire department it was that arrived?
Lawrence.
Lawrence? Okay. And did you ever go over to the location where Mr. Stermer was lying on the ground?
No, I avoided it.
Okay. From the position that you were at, did you detect any unusual odor?
No.
Okay. Now, Where was the van parked at?
It was behind the house. It was down the hill and around behind the house. You couldn't see it from the front of the house.
Okay. Okay. And what was the ground like?
It was slippery. It was kind of muddy.
Kinda, or was it muddy?
Well, it was muddy.
Okay.
Yeah.
Okay. Okay. And at that time, was it still raining?
It had started to rain after we were there a while.
Okay.
Yeah.
Okay. And do you recall the clothing that Miss Stermer had on?
I do.
Okay. Could you describe what you saw?
She had a t-shirt, gym shorts, and white socks. Just socks, no shoes.
And shorts. Mm-hmm. And a t-shirt.
Yes.
What would you estimate, just based upon your feelings of the weather then, what would you estimate the temperature to have been at that time when you arrived?
At that time when I saw Linda, I don't know. I'm not sure. I couldn't say. But the temperature was dropping fast.
Dropping fast?
Yeah.
Okay.
It started out as a rain, and then it started to spit snow-rain mix.
Okay.
Yeah.
And were you were there when some of the law enforcement officers arrived, or were you?
I really didn't notice them. You know, I was with the firefighters. I heard the sirens and everything coming. I did see one deputy's vehicle.
Okay.
Yeah.
But you were familiar with some of the personnel of the fire department, is that right?
Oh, yes.
Okay. Had you ever worked in the fire department?
I never did. No.
Okay.
They asked me to join, but I thought they'd be better served with spending their training money on a younger person. But several times I've, just been on scene just to assist in any way, carry a ladder, carry a hose, do whatever.
It's a volunteer?
Yes.
Yes. Okay.
Yes.
Okay.
My wife was on the township board, and she was, it's a small town, and everybody kind of helps each other.
Right.
Yeah.
That's why the motto is "We grow together," right?
Yes.
Yes. Now, you stated in direct that someone asked you to watch the van.
Yes.
Do you recall who?
The deputy asked the assistant chief, Doug Harrington, and Doug Harrington asked me to help in that.
So you saying the deputy
had asked Doug Harrington to make sure that no water got sprayed on there and nobody, touched the van. And he asked me to help him in that.
Okay. So in putting out the fire, they wanted to make sure that the van didn't get hit with the water, is that what they were talking about?
Right.
But you wasn't directed to move the van, though, right?
I don't think you could have, because it was that muddy. I don't know if you could have moved the van.
Okay.
Yeah.
Okay. Okay.
I think you would have had to have it towed.
Okay. And so approximately how long did you remain on the scene?
Like I say, we didn't get home. It was pretty late. It was pretty late. I would say we were there 5 hours.
Okay. And you recall someone bringing Miss Stermer some clothes, right?
I know the girls, Linda wanted my wife's Aunt Gail to bring her some clothes and shoes, and she just wanted her there maybe for comfort or whatever.
Okay. Okay. And so, since 2007, you haven't had to speak of this case to anyone in law enforcement?
No. No one in law enforcement.
And on that date, did any of the law enforcements that arrived, did any of them take an interview statement from you?
No.
Okay. Just a second. Mr. Thompson, let me, you recall the fact that there was two dogs at the house?
I saw one dog.
You saw one dog?
Yes.
Were you part of rescuing the dogs?
Yes. While we were standing down there by the van, the basement window had been broken out, and the dog kept jumping through the window into the fire. I think the dog was just traumatized, and it kept jumping back and forth in and out of the window, and we were trying to catch it.
Did you have to go inside to get him?
No.
Okay.
No.
But you was able to ultimately rescue him?
Yes.
Okay.
Yes, and then we kept the dog for Linda and the children.
Okay.
Yes.
Okay. And did you see anything on the van in reference to any type of blood on the van?
Yes.
Okay. And where did you see that at?
As I remember, it was down the front of the van, and then on the bumper, and then kind of, it seems like, to the best of my recollection, it was led underneath the van.
Underneath the van?
Yes.
Okay. Did you get down and look up underneath the van?
Well, I didn't get down on my knees or anything.
Okay.
But yeah.
Okay. Was it just on the front, or
That's all I saw was
just on the front?
on the front. Yes.
Okay. But you don't know what caused
No.
blood to be on the van?
I had no idea.
And you don't know what caused the fire?
No idea.
Okay. And my last question, when you said you first approached Linda Stermer, you stated that she was traumatized, in your opinion?
Yes.
Okay. And she couldn't speak, or did she speak?
Well,
to you?
she could speak, but she wasn't making a lot of sense. She was sobbing, and, when I first asked her where the children were, I think her response was, I don't know. And that's what led me to, I was going to go through the front door and see if I could do anything for the children. But then as I headed for the door, she told me, no, there's nobody in there. The children are somewhere.
While you were on the location, where was the great amount of flames and smoke that you identified while you were present there?
Well, I was toward the back of the house with Doug Harrington, and so that's where I saw the most flames.
From the back of the house?
Right.
Okay.
But I don't know at that time what was going on with the front of the house. I was, in the back.
Okay.
Good, you're done? Okay. Ms. Seidemann?
Thank you, Your Honor. So I just want to clarify, when you first got there, you saw the smoke on the top. There were no holes in the roof at that time?
No.
Fire hadn't broken through
Just
yet?
smoke, yeah.
Okay. And was Mr. Matheny, did I remember you saying he was there?
Yeah, I didn't realize it was him, but I recognized the truck, and it was off to the side. He was kind of off to the side.
Okay, so he was there when you and Steve Leach were there as well?
Yes.
Okay. And did you smell the fire?
Did I smell the fire? I can't say I recall smelling anything.
Don't remember.
No.
And you arrived, were there law enforcement at the end of the driveway when you arrived?
I don't recall.
And you didn't put your name on a list or anything while you were on scene?
No, nobody asked me anything that night.
And you left then before you actually talked to the law enforcement?
Right. Yeah, when the fire department left, we left.
So you were actually kind of with the firemen and helping them out?
Yes,
So the dog was jumping in the basement window?
it was.
Was-
Probably 4 or 5 times.
So the dog get burnt?
No, the dog would jump through the window, and then the flames would drive it back and jump out the window, and then we'd try to catch it, and it would run around a circle and jump back in the window.
So there weren't any flames coming out the window?
No, but you could see flames inside.
And if I told you that the dispatch call came in around 3:30, would that surprise you?
No, it was, that seems appropriate.
Seems about right time?
Yes.
In terms of the events of that day?
Yes,
Fits in with your cutting of the firewood?
right.
So I'm guessing, were you looking at a watch or a clock?
Not at all.
I have no further questions, Your Honor. Thank
Every
you.
day is work from daylight to dark.
I have no further questions.
Jury, any questions of this witness? Anyone? I've got one hand going up. Did you assist at all with covering Todd with any clothing?
No,
Okay, thank you.
no.
Any other questions? Any questions in light of the question asked and answered?
No, Your Honor.
Mr. Kelly, any questions of him? Any more? No. Thank you, sir. Can he be excused from subpoena?
I would ask that you please be excused.
Any objection to that, to excusing him from his subpoena?
Yes.
Good? Okay, thank you. You're done and you're excused from your obligation under subpoena, sir.
Thank you, Mr. Thompson.
Counsel, can you approach, please?
Yes, Your Honor.
Break, and remember your admonitions, do not watch any media reports or talk to each other. Same old thing all over again, but it's very, very important. So you can leave your binders in your chairs. And this will be about a 15-minute break. are back on the record in the case of People versus Linda Stermer. Any matters to address before we bring in the jury?
No, Your Honor.
Defense, any matters to address?
No, Your Honor.
Thank you. Bring in the jury. About to give in this cause will be the truth, the whole truth, and nothing but the truth? I do. Thank you. Please have a seat. And once you're settled and comfortable, we'll have you give us your full name and spell the last. The microphone you can move close to your mouth so the jury can hear you. You are your name and last name, or spell your last name, please.
First is Verge, and last name Franks, Franks.
Thank you, Ms. Zeigerman.
Thank you, Your Honor. Mr. Franks, what was your current occupation, or sorry, what is your current occupation?
Right now, I am retired.
And what did you do prior?
I worked for the Sheriff's Office in Van Buren County.
For how many years?
34 and a half.
And were you acting in your capacity as a sheriff deputy on January 7th of 2007?
I was.
And were you involved in the investigation of the Stermer home?
I was, yes.
Can you tell us what, when you first heard of this, or what, how you became aware of this, what was happening?
At the time, I was shift supervisor, rank of sergeant with the patrol division. One of my deputies, Deputy Evans, notified me and mentioned that he had a fatality and a structure fire, and asked that I come down to the scene, so I did.
And so you went down immediately then after receiving that call?
I did, yes.
And you arrived then at the Stermer home?
Yes, I did.
And did you drive down the driveway, or did you park in the street, or something else?
I parked along the main street. I did not pull into the driveway.
And then was that County Road 215?
Yes.
And did you walk down the driveway?
I did, yes.
Can you describe that driveway for the jury?
Non-paved driveway. My best guess, and only a guess, is around 150 to 200 yards. The actual surface at the time was muddy and wet. It was that time of year, in that particular year, where there was rain and snow that day.
And was the rain and snow occurring when you had arrived?
I remember a wet driveway and fire apparatus coming and going. I think water shuttling possibly, and didn't want to get in the way of the fire trucks. Is basically why I parked where I did.
So the fire trucks were going up and down the driveway?
Yes.
And do you recall how many trucks?
I do not.
Any issues with the fire trucks getting up and down the driveway?
I do not remember any issues.
And when you arrived, what did you observe?
Emergency personnel on scene, an ambulance, fire apparatus, firefighters and their fire turnout gear, and law enforcement.
And do you recall what you noticed or observed about the fire itself? What stage it was in or where it was at?
I don't remember it being still a working fire. I don't remember seeing flames. There was smoke. Whether that was smoke or steam due to suppression efforts, or if it was still actively burning, I do not know.
So the fire department was actively fighting the fire when you arrived?
Yes.
And so what was your role on scene?
I was shift supervisor at the time in the patrol division. Made contact with Deputy Evans, and after being briefed by him, made a decision, and that was to request our criminal investigation division to come out.
And would that have been Detective Maziowski and Detective Rout?
Yes.
And did you assist in any way with collection of Linda Stermer's clothing?
I did, yes.
And how did that come about?
The recollection that I have isn't crystal clear, but I was involved in retrieving clothing that Linda Stermer was wearing when I got to the scene.
And so it was handed to you and you collected it?
Yes, but I do not remember who handed it to me.
Do you remember where it was handed to you from?
My recollection is that Linda Stermer was inside an ambulance, and that the clothes were handed to me near the ambulance or from the ambulance.
I'm going to show you what can be marked as People's Proposed Exhibit number 3. Your Honor, may I approach? Do you recognize this package? Please tell me how.
I do.
And how do you know what that? How do you recognize it?
The labeling here, and also some of it's coming back to me now after seeing this. There is a sweater, a pair of pants, and socks, and these were what Linda Stermer was wearing when I got to the scene.
And these are the items of clothing you collected?
Yes, they are.
Your Honor, at this time I move for admission for People's Exhibit number 3 into evidence. Number 3. Thank you, Your Honor. And so you collected these items from personnel then on scene, and can you tell the court then what you did with those items?
Deputy Evans, who I referenced before, he was our evidence technician at the time, and I handed these articles of clothing to Deputy Evans. He was our professional evidence handler, and any packaging would have been done by Deputy Evans for chain of custody purposes.
And you didn't have any involvement then with that evidence after you collected it and handed it off to Tony Evans?
I did not.
Anything else that you collected on scene?
No.
Any other roles that you were involved in on scene other than just being in charge and pretty much being aware of what was happening?
General logistics, that type of thing, dealing with our victim services unit and other officers that came and went. Also, when the medical examiner's office arrived, I had a role in assisting her there at the scene.
What was your role there with her, with assisting her?
As I recall, her name was Amy Darling, and as I recall, there came a point in time when it was necessary for her and her duties just to examine the body of our deceased victim, and I assisted with helping to roll the body so she could see all parts, all sides of the victim's body.
And so you actually physically assisted in rolling them over?
I did.
And could you describe the injuries that you saw?
I saw what I think are extensive burns, hair from the head. If there was anything to begin with, it was burned away. Some loosening skin, like really loose, around the arms, hands, if I recall that. And I recall just some type of pants that the victim had on, and that's all that I recall. The torso was exposed, and looked like some types of injuries along the back, and then the head, there was blood from the head.
So you saw blood from the head?
Yes.
And did you see any of the injuries on the head?
I didn't look at those. That's what the medical examiner's office was doing. I was just helping.
So this was just your basic observation?
Yes.
Your Honor, permission to publish and to pass around the item number 3. And I have no further questions.
Mr. Pelton or Mr. Newell? Any questions?
Yes. So Deputy Franks, how long have you served on the Van Buren Sheriff's Department?
34 and a half years. I was
34?
hired- Yes, hired in 89, retired in 2021.
Retired in 2021?
Yes.
Okay. Now, you stated that when you arrived at the Stermer property on January the 7th, 2007, who all was present when you arrived?
I recall Deputy Evans with the Van Buren Sheriff's Office. I recall Deputy Gary Druss with the Van Buren Sheriff's Office. I do not recall any other law enforcement when I first arrived.
So it was Deputy Evans and Deputy Russ?
Druss, it's G-U-R-S-S, Deputy Gary Druss.
Okay. And were there first responders there? The ambulance was the ambulance there when you arrived?
I do recall an ambulance there. I do recall fire apparatus and firefighters in their coats and helmets, but I don't know who they were.
Okay. And your position at that time was what rank did you have at the?
I was patrol sergeant. I was just a shift supervisor in the
Okay.
Uniform Services Division.
Okay. So the call comes in and you just show up because it's in the area, right?
Yes, Deputy Evans specifically reached out to me as his first supervisor to respond to the scene.
Okay.
He was following chain of command.
Okay. Okay. And did you see the state of the fire when you arrived?
The best I can recall is that there was smoke, but I don't recall seeing flames when I arrived.
Okay.
But it was an active scene, and what I mean by an active fire scene is there were fire apparatus were there. You could see that the firefighters were doing different tasks. I didn't focus on that. I was basically being briefed by Deputy Evans, but I could see all this going in the peripheral.
Okay. And did you? So where did you and Deputy Evans station at when you arrived at the scene? Were y'all in the front of the house, or were you in the side of the house, or the back of the house?
I came in from County Road 215, which is east of the residence. So when I spoke with Deputy Evans, it would have been in the yard or the lawn area. Best recollection would be to the east, basically the east, maybe slightly northeast of the residence. So between the residence and County Road 215.
Okay. What was the weather conditions like, as you recall?
I recall the driveway being wet, muddy. I know at some point there was rain, and then later on into the evening, I know there was some snow. But I don't remember when I first got there what was going on with the atmosphere.
Do you recall where the ambulance was positioned when you arrived?
It was in the lawn, east of the residence.
Okay.
It could have been on a driveway. I don't recall the actual structure of the driveway, but it was in the driveway or lawn, that curtilage area around the house.
Okay. And you went to the ambulance, is that correct?
Sometime during the afternoon or evening I did. I don't recall when exactly that was. I was there for some time, probably a period of hours at the scene. I don't remember at what time I went to the ambulance itself.
You don't recall how long you were there?
I do not.
Okay. Do you recall, based on your position, did you reduce your activities to a written report?
I did not. As a patrol sergeant, it's common for me just to have a subordinate deputy, so to speak, just include what I did in their report.
Okay. Okay. Do you have to review that report?
Oh, yes.
Okay. Do you know, would that report have been prepared by Deputy Evans?
Yes.
Okay. Okay. And how were you the assigned individual to collect the clothing of Miss Stermer?
That I do not recall. If that was something I was asked to do by the detectives, I don't remember if it was done pursuant to any of the actions they were taking.
Do you know who the detective was?
We had a detective, a sergeant named Thomas Maziowski, and a detective named Gabrielle Roth that were both on scene.
Okay.
So it could have been either of those two that asked for that to have happened.
Okay. And can you tell us how the exchange of the clothes occurred? Were you given a bag or just the loose clothes and asked to preserve those items?
That I do not recall. I do not recall if the clothing was handed to me directly from Linda Stermer, or if there was other staff, such as our victim services unit ladies that were there. My recollection is the clothing was that Linda Stermer changed her clothing inside the privacy of an ambulance. How I got to take first possession of those 3 articles of clothing, I don't remember. If Linda Stermer came out dressed in other clothing and gave them to me, or if someone else that was inside the ambulance with her would have given them to me.
Do you recall what the state of the clothing were when you received them?
I do not.
You don't recall whether or not they were wet?
I do not.
What is your procedure for preserving the items that you have received? I assume that at that time you considered these items to be of some evidentiary value, right?
Yes.
And that there would have been a chain of custody in reference to maintaining the items, right?
In this situation, at this particular scene, the exchange from my possession of the 3 articles of clothing to Deputy Evans would have been nearly immediate, as he was on the same scene with me. So I wouldn't have taken the clothing away and given them to him, say at the station or a different location. It would have been fairly fluid.
But they were already bagged when they were given to you?
That I do not recall.
Okay.
I did not package or bag the clothing. I don't remember doing that.
And do you recall whether or not you took any pictures of the items?
I know I did not.
Okay. And they were placed in your patrol car, or were you driving your personal car?
I don't have a recollection of that. I can speculate, but I don't have a recollection.
Okay, okay, that's fair. But at some point in time, you transferred the items to the sheriff's department, is that right?
I would have given the items, the 3 articles of clothing, to Deputy Evans himself.
Okay. But Deputy Evans was at the scene, right?
Yes.
So when you received the items, they were placed in your patrol car or your vehicle, right?
He's actually placing words into the witness's mouth. I'd ask that he just ask questions. I don't think there's been testimony that's placed in the patrol car, so he's actually testifying and placing those words out there even before the witness has said them.
Your Honor, I was going to clarify, I just was saying vehicle.
It's also asked and answered.
It's getting, I agree with that.
But-
Have you move
Thank
on?
you, Judge. I'll move on. You placed the items in a vehicle and transported them to the sheriff's office.
I do not recollect that, and I'm leery of speculating or trying to give you what I believe I would have done.
My point is, I'm just trying to find out, when did they get to Deputy Evans?
Could I answer what is likely?
But not what you really know.
Yes.
So you really don't know when they got to Deputy Evans?
I do not.
Thank you. Was there any other involvement that you had, Deputy, while you were there on the scene the day of the fire?
Not to what I've already testified to. Nothing additional.
Nothing additional?
No, sir.
Okay. No interviews with any persons or anybody that was there on the scene?
None.
Okay. But you were there for approximately 3 hours?
I don't recall. I know it was a period of hours.
Okay. But during that time, were you just standing around?
There are different responsibilities, different scenes are dynamic sometimes. I don't recall exactly every minute what I did do there. I could give examples. I mean, at one point, I was using the telephone, to have dispatch send our detective division out. Our victim services unit was there, which are volunteer civilians that we utilize in types of tragedies and that type of thing. I would have dealt with them. Other than that, I would have just been there, keep maintaining a presence, yes.
Thank you. I have no further questions, Your Honor.
Follow-up, Ms. Siderveen?
No further questions, Your Honor.
Jury, do you have questions of this witness? No? Okay. May he be excused from his subpoena, counsel? Excused from subpoena?
I'd ask you to get the
Oh, I'm sorry, we've got a question. Questions from the jury, no objection from counsel. Did you notice a van on the premises?
I did, yes.
As an investigator, were you informed about the blood on the van?
I was, yes.
Okay. Counsel, any questions in light of those questions and answers?
No, Your Honor.
I just have one question.
Okay.
Deputy Franks, who was it that informed you about the van?
That I do not remember. However, at the scene, during the course of the investigation and throughout the few hours that I was at the scene, I had occasion to brief with or be briefed by our detective division. Once the detective division got there, as far as hierarchy, chain of command, they would have been in charge. And I do not remember exactly which person told me that, but it was during one of our huddles or one of our briefings there at the scene that I was informed of that.
Okay. That was it? That was it?
That was it, yes.
So you didn't ever go and actually do a physical inspection of the van yourself?
No, and why I did not was because I was a sergeant, basically a road sergeant, a patrol sergeant. Our criminal investigators, our detectives, that's their purview. That's what they're there for.
Okay.
So I did not usurp their responsibility.
Okay. All right. Thank you.
Ms. Zeiderding?
No further questions, Your Honor.
Jury, any other questions of him? No? And you both agreed to excuse him from subpoena, correct?
Yes.
Okay. Thank you, sir. You're all done.
Thank you.
Ms. Zeiderding?
Thank you, Your Honor. People call Dr. Michael Markey.
Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. When you get settled in, if you could give us your full name and spell the last, please.
My name is Michael Allen Markey, M-A-R-K-E-Y.
Thank you.
Dr. Markey, what is your current occupation?
I'm a physician, more specifically, I'm a forensic pathologist.
And what does a forensic pathologist do?
Forensic pathologist is a physician that has specialized in the field of pathology, which is essentially a branch of medicine that utilizes examining body tissues, either the whole body tissue or tissues removed at biopsy or at surgery to make diagnoses. Forensic pathology is a further subspecialty of pathology in which the pathologist has additional training in performing autopsies, especially forensic autopsies, those that fall under a medical legal death investigation purview to determine generally cause and manner of death.
And how long have you been a forensic pathologist?
I've been practicing as a forensic pathologist since 2002, so 23 years.
And how many autopsies have you performed?
Several thousand.
And as part of preparation for today, did you give me a current curriculum vitae?
Yes.
And, Your Honor, may I approach?
Can you just look through his and see if you recognize that?
Yeah, that's actually an older copy of my CV, but this was actually from back in 2009. But it would have been accurate accurate as of that time.
Accurate at that time. And so that is a copy of your curriculum vitae?
It is. It's not the most recent one. I do have a recent one with me if you would prefer to have it.
And I think we're fine even just using this one. And I believe at this time, both council have stipulated to its admission as a People's Exhibit number 4.
Any objection?
No, we stipulated, Your Honor.
Court will receive People's Exhibit 4.
Thank you, Your Honor. Permission to just publish. And on that curriculum vitae, it lists out all your professional experience up to 2009 and pretty much your education and your role.
Yes.
And you've remained in that role from 2009 until current, is that correct?
Yes.
And as part of your, and Your Honor, at this time, I would also move to admit him as an expert in the field of forensic pathology.
Any objection, defense?
No, Your Honor.
Okay, we'll receive his testimony as an expert in the field of forensic pathology.
Thank you, Your Honor. On January 8th, on 2010, did you perform an autopsy on Todd Stermer?
I think it was in January of 2007.
I'm sorry, you were correct, 2007. Thank you for that correction. Was that the first time that you had ever seen Todd Stermer?
Yes.
And can you describe how a body comes to, actually let me ask you this first, where are you currently working?
I work at the University of Michigan Health, Sparrow, Lansing, in Lansing, Michigan.
Is that where you were working in 2007 when you did this autopsy?
Yes, it was called Sparrow Hospital then, but it's the same place.
So can you explain to the jury how the body arrives when it arrives to your facility?
Right, so both then and now. In this specific instance, I wasn't the medical examiner for Van Buren County. I was serving as a consultant forensic pathologist. So when the medical examiner in Van Buren County needed an autopsy performed to fulfill their duties, the body would be sent to Sparrow Hospital by a transport service, logged into the morgue, and then one of the forensic pathologists there would subsequently perform the autopsy. On this date, I was assigned to autopsies in the morgue, and I performed the autopsy.
So does the body arrive in a body bag?
Yes. So typically, the body is within a zippered body bag. Many times there's actually a seal on the body bag to indicate that it was sealed at the scene and that it's still sealed when I open it, and it will typically also be labeled, usually with an identification tag indicating the individual's name.
Is that how Todd Stermer arrived in this case at Sparrow?
Yes, I believe he was in a body bag, and the tag on the body bag and on the body itself actually indicated his name.
So when you begin your autopsy, do you have to break that initial seal?
Yes. I oftentimes don't. I have assistants that assist me with the autopsy. They often actually do the breaking of the seal, but it's not broken until the autopsy is scheduled to begin.
And what is the purpose of that seal?
The seal is just for preservation of what we would consider the chain of custody. It gives me confidence that no one has entered the body bag and altered the body in any fashion prior to my examination.
And do you recall how long this autopsy lasted?
Boy, it's been a long time ago, so I don't. A typical autopsy that's would usually take me a couple of hours. So my guess would be at least a couple of hours. It may have been a little bit longer, given the type of case that this was.
And you said that this took place at Sparrow at that time?
It did, yes.
Was law enforcement present for the autopsy?
Yes, according to my report, which I've reviewed and have brought a copy of, there was I believe a detective with the Van Buren County Sheriff's Department that was in attendance at the autopsy.
Did you release items to law enforcement at the conclusion of that autopsy?
Yes.
And do you recall what items?
There were some items of clothing that were released, I believe, fingerprints that we took at the autopsy of the decedent's fingers. I believe a DNA card prepared from blood that we collected at autopsy. And typically we would have released a copy of the photographs of the autopsy that we took at the time.
Do you recall, or do you have it in your report of if the body had any clothing on it when you first observed it?
Yes, the only clothing that was being worn on the body were 2 socks, one on each foot. There was additional clothing that was with the body. I believe there was a pair of underpants. They weren't on the body, but they were in the body bag with the body. And then there was some sort of long sleeve shirt that wasn't being worn, but that was sort of draped over the front of the body, covering sort of the torso and genitalia area.
Do you recall any sweatpants?
No.
And that those items of clothing are then what you were talking about when you said clothing was released to law enforcement?
Yes, the clothing that was present when the body was received in the morgue.
Before starting an autopsy, is there a particular procedure that you follow?
Yes, so I have some idea as to the circumstances. Any history that's provided, I try to review ahead of the autopsy. Any investigative reports, either from the medical examiner's office or from investigating law enforcement, if there's any medical records that are present, anything that may give me an idea of, what the person's health history is and what the circumstances around their death were. Were they in a car crash? Were they apparently shot at? It somewhat alters a little bit the procedures that we perform during the specific autopsy.
So you were aware of some of the basic facts of this when you started your examination?
Yes.
Do you recall what basic facts you knew at that time?
Yeah, very basic. I knew that he had been in a house fire and had been found outside, and that he may have been struck by a vehicle after the fire.
Can you explain to the jury what your initial observations of the body were?
Yes, so the first observations of the body are, as it's received to me. So he had the clothing on and with him. There was some evidence that they had attempted to resuscitate him. I think he had a small catheter in his neck from, EMS attempting to establish an airway. I think he had some defibrillator pads and maybe an EKG pad on him. I think there might have been an IV in place. I'd have to look at my report specifically. But there was evidence that he had a resuscitation attempt. He also had obvious diffuse burns over the majority of his body.
And when you say the majority of his body, can you give me an idea of percentage?
It was probably over 90%. The only place that the skin was still relatively intact and somewhat normal were on his feet, where they would have been protected by the socks that he was wearing, and I think a little bit more on one of the legs, like maybe up to around the knee, but it wasn't all intact. It was just partially intact there. I think for the most part, the skin was generally burned and the surface skin absent over the rest of the body.
Did you observe any sort of lacerations?
Yes, he did have some what we would call blunt force injuries, so injuries caused by impact with a non-sharp object or a blunt object. He had lacerations of his head. There were 4 specific lacerations. One was on the top of his head, one was on the back of his head, and there was one on each side of his head, generally above the level of the ears. There were also larger lacerations or skin tears. That's basically what a laceration is, a skin tear or skin split. One was on the inside of his left upper arm. One was on kind of the right upper back of the shoulder area. And then there was a smaller, more superficial one sort of on the lateral or left side of his chest and back.
What was the largest of the lacerations on the head?
There were 2 lacerations that were around 2 inches, maybe a little over 2 inches long. Those were the ones that were on the top of the head and the back of the head.
Once you complete then your first examination of the body, then what's your next step?
So essentially, the next step is removing the medical devices, removing the clothing, removing anything that may obscure the body examination. If the body has any blood or dirt or anything else on it that may be obscuring my ability to see what's on the surface of the body, that's removed. So generally, medical devices are removed, clothing is removed, the body's cleaned up, and then basically the same sort of examination is done on the external surfaces of the body, now with just those materials removed. In this case, there wasn't much to remove, so there wasn't much additional to see on the external surfaces of the body.
And then what would be the next step after you've done that initial?
Right, so the next general step is the performance of an internal examination. So after we've looked at the outside of the body, now we make incisions, just like surgeons do in the body, to expose the body cavities and the organs in the body. So incisions are made on the chest and abdomen to examine the internal structures of the torso. A reflection or an incision is made in the scalp to expose the skull. Portion of the skull is removed to examine the brain, and then the neck structures are exposed and examined.
So as part of your internal examination, do you document then your findings?
Yes, so I would document the general appearance of the organs, any evidence of natural disease involving those organs or tissues, and any injuries that I can appreciate.
Your Honor, may I approach? I'm going to show you what's been marked as People's Proposed Exhibit number 5. Can you tell me, after looking through those pages, if you recognize this?
Yes, this looks like a copy of the autopsy report that I authored following the conclusion of the autopsy. And there are actually 2 page 8s in here, but there's a total of 9 pages. And attached to that is the toxicology report.
And is that toxicology report part of your medical documentation with the autopsy?
Yes.
Your Honor, I would move for people's admission of People's Exhibit number 5 at this time.
Your Honor, if I can just see that, I just want to clarify something with counsel. We're good.
Yes, Your Honor. This is People's Exhibit number 5.
Thank you. We'll admit People's 5.
Thank you. And I'm going to go ahead and put that, permission to publish, I'm going to put it up on the screen so that we can discuss your findings. So what I'm showing is this, what you have is page 1.
Yes.
And can you go through what we're looking at here on page 1?
Yes, so at the top are just the demographic information, the patient's name, the case number that was assigned to it, date of birth, his gender, when the autopsy occurred, who was present, etc. And I already see that, unfortunately, I made a typographical error on the date of his death. It should be 2007 and not 2006. I must admit I'm pretty slow at my year changes when the year changes from one to the next. And then after that is an outline that lists the diagnostic findings of the examination. So it's essentially this page, and what spills onto the next page is a summary of the diagnoses that are described in more detail in the rest of the body of the report.
So it looks like on paragraph number 1 with the thermal injuries, we've already then discussed that. Is that correct?
Yes, I diagnosed thermal injuries, what are more traditionally known as burns, over most of the body. In addition, he had evidence that he had inhaled what we call products of combustion, which are the materials that are produced when something burns. So essentially the smoke or the soot, the gases.
And is that a significant finding in terms to maybe timing of death?
The inhalation of products of combustion are, at least in my field, when we're examining a burned body, one of the questions is whether the person was alive or not during the fire. And finding evidence that they inhaled the smoke and soot, the products of combustion, indicates that they were alive and breathing at the time that the fire was occurring. So the fact that there was evidence that he inhaled such products were indicative of him being alive at the time of the fire, and also may indicate that he may have had some inhalational injuries as well, or injuries related to inhaling the smoke and soot.
And if we move then to the section number 2 on the blunt force injuries, I believe you've talked a little bit about that, but can you go into a little more detail? It appears that there's a little bit more explanation and some additional findings.
Right, sure. So under Roman numeral number 2, capital A, are the lacerations or the skin tears that were on his scalp. Beneath 2 of those lacerations, the 2 that were on either side of the head, there were very small, about 1/4 to 1/2 inch length indentations. Some might call them depressed fractures of the skull. They were very superficial, and they just involved the exterior surface of the skull. So underneath 2 of those lacerations, the skull was, for lack of a better word, had small dents related to the impacts. But there were no internal injuries in the brain otherwise. The brain itself looked normal. There was no bleeding in the brain or around the brain to suggest a brain injury. Capital B lists superficial linear abrasions. So abrasions are essentially scrapes or scratches. So it's a blunt force injury generally caused by friction. So classic examples, if you fall onto like the sidewalk and scrape your knee, that's an abrasion. He had lots of linear, which means line-like abrasions scattered around on various surfaces of the body. There were the lacerations of the right shoulder or upper back, the left upper arm, and the lateral left back and chest, which I noted earlier. And then there were a couple of other internal injuries that I only saw when I examined the internal aspects of the body. There were fractures of 2 ribs on the left side, left rib number 3 and 4. They were fractured in what I describe as the anterolateral position. Antero means front, posterior means back. So they were on the front side of the back, but closer to the outside of the chest than the midline of the chest. Those types of fractures can be seen with chest compressions during CPR. It's where the ribs kind of bend when you're pressing on the chest. There was one right rib that was fractured, right rib number 3, and it was fractured posteriorly or on its back aspect. And then the only other internal injury that I appreciated was focal hemorrhage or bleeding in the tip of the tongue.
So I just want to ask a few questions about some of those. You had mentioned that the shallow depressions, those were shallow depressions in the actual skull bone?
Yes, in the bone itself.
And you said that some of the rib fractures may have been caused then by, or what you typically see in chest compressions. Is that correct?
Yes, I mean, obviously I can't tell exactly what caused those rib fractures. There are multiple ways that ribs can be fractured, but in my line of work, we see many people that have had chest compressions before they die, and it's not uncommon to see fractures in those locations during those situations.
Were there any rib fractures that he sustained that would not have been something you commonly see with CPR?
Yeah, the right rib fracture, the fracture that was in the back, would be uncommon to be seen during CPR. Generally, you don't fracture ribs in the back when doing that.
And I believe we've covered all of those on the injuries. And I want to just clarify the blunt force trauma. Again, how is blunt force trauma? How does that happen to a patient?
So a blunt force injury is one in which something that's essentially blunt or not sharp impacts the body or the body impacts such a surface. So, being struck with something like a board or something that's not got a sharp edge will cause a blunt force injury. And classic blunt force injuries are either abrasions, scrapes, contusions, which are bruises, or lacerations, which are skin splits or skin tears. Conversely, if part of the body strikes another object that's blunt, you can see the same thing. So if you fall to the ground and hit your head on the floor, you may end up with a bruise or a laceration. So it's either something blunt striking the body or the body striking something with a blunt edge or a blunt surface as opposed to a sharp surface.
And you said there were no injuries to the brain or brain bleeding associated with the skull depressions. Is that correct?
That is correct.
Is it possible to knock someone unconscious with a blunt object and not have bleeding or brain injury?
Yes, that's essentially what a concussion is, where you have an alteration in consciousness due to an injury that typically isn't necessarily caused by some obvious visible injury to the brain.
I want to, and I apologize, I forgot to ask you a question with the soot in the airways. You said that it indicates he was alive at the time of the fire, correct?
Yes.
And is there some sort of relationship to the proximity of the fire that you look at in terms of the amount of the soot in the lungs?
Well, I'm not sure I understand the question exactly, but the more smoke and soot that's being produced by the fire, and the longer you're in that atmosphere breathing it, the more soot you're going to have. So, for example, many individuals that die in house fires don't really die from burns. House catches on fire, they get away from the actual flame fire itself, but they're in an environment where they're breathing in lots of the smoke and the soot, and they die essentially from inhaling the products of combustion. In those instances, usually there's a large amount of soot, black material, in the nose, in the mouth, in the airways, and when we measure at least one of the gases that's present during fires, specifically carbon monoxide, when we measure concentrations of carbon monoxide in those individuals who die under those circumstances, the carbon monoxide concentration is usually quite high. In individuals who are not in a smoke-filled environment very long, would expect to have less soot and therefore not as much carbon monoxide and other gases present. It's also been my experience that when an individual is on fire, as opposed to just being in a fire, they tend to inhale less smoke soot. We give off less products of combustion when we are on fire than, let's say, this building with all of the wood in it would. I don't know if that answers the question or not.
Yes, it does. Thank you very much. And as part of your report, did you determine the cause and manner of death?
I determined the cause of death were thermal injuries or burns and inhalation of products of combustion due to the fire. Manner of death is something that goes on the death certificate that the medical examiner in each county is responsible for filing. It's essentially for public health and data collection. It's not really supposed to be a determination of legal or judicial responsibility for the death. In this case, because I wasn't sure at the time of the autopsy and at the time of issuing my report the exact details of how the fire was started, how he came to be burned, I offered my opinion to the medical examiner here in Van Buren County that I would classify the manner of death as undetermined.
And that's on your report?
Yes.
And so then that is on the page that you have, I'm sorry, what page number is that?
Yes, that opinion
page number
is,
2?
yes, is on page 2.
Okay. Pardon me?
I thought the jury might be passing it around.
Oh, no, I actually have it up on the screen too. Thank you. So I just want to give you a hypothetical. So if somebody is standing out in the middle of the road and is hit by a car and you do the autopsy, would it be a very similar sort of manner?
Yeah, again, it all depends on the circumstances as I know them at the time. So if someone is found dead in the roadway and I do the autopsy and they have lots of injuries that are consistent with being struck by a vehicle, the cause of death is fairly straightforward. He died of those injuries, blunt force injuries due to being struck by a vehicle. If I know no circumstances whatsoever, or the circumstances aren't very clear about how he ended up being struck, then I would typically give an opinion that the manner of death is undetermined. I don't know the circumstances around which they happened. You know, if it happened to be witnessed, or you know, it's on video, or you know, there's good information provided that you know he had just walked out of the bar and stumbled into the road, and a passing motorist coming around a curve hit him and had no time to evade him, then classically that would be called an accidental death. There was really no intent for that person to harm him. If on the other hand, you know, he had been in a fight and the person that he was in a fight with got in his vehicle and as he was running down the road, barreled over him in an attempt to intentionally harm him, then for purposes of death certification, that death would be classified as a homicide. But if all I know is he's found dead in the road and we don't know exactly the circumstances about how he came to be hit by a vehicle, then I would classify the manner of death as undetermined.
You said that they had the 4 different lacerations on the head. Do you have an opinion other than blunt force trauma of how those were inflicted?
I can't tell you exactly how those were inflicted. There's nothing very specific about a skin tear that allows me to say, you know, it was caused by being hit with this or being struck by that. They're relatively nonspecific. Some lacerations are patterned, and I can get some idea these were not patterned in any way, so I don't know exactly what his head struck or what struck him in the head.
And at the time you did the autopsy, you said you had reviewed the information and you were aware he had been run over by a car, correct?
Yeah, I think the information I had at the time was that there was a vehicle at the scene and that there was apparent blood or some body tissue on parts of the car that suggested to the investigators that he had been struck by the vehicle.
And with those injuries, could they be comparable then to what you would see with somebody being hit by a car?
Yeah, I mean, the typical injuries that we would see in someone that's struck by a car, depending again on how they're struck and at what speeds, are things like abrasions and contusions and lacerations. So the fact that he has some abrasions could be from being, either striking, parts of the vehicle. The types of abrasions he had were more kind of the scratches and scrapes that you might get from the ground or from being under a vehicle and being sort of dragged or hitting things underneath there. The lacerations are non-specific. They could be from striking parts of the vehicle as well.
Could they also be from being struck by something else?
Yeah, I can't say with certainty what the impacting object was.
So if he was hit with an object before he was hit by the car, you wouldn't be able to differentiate that without a pattern?
Not in this case, no.
Are you able to determine if the injuries were inflicted before or after the thermal injuries, the burns?
I can't say with certainty whether they were or not. In some instances with burns, if there's an injury there prior to the thermal injury or the burn, it will also show burn injuries. In this case, since the burns were mostly just on the surface of the skin and there weren't burns down into the depth of the injuries, I can't definitively say that they were there beforehand and therefore that the exposed tissue also burned. But due to the degree of burning, I can't exclude that they were there before.
Typically, do burns of this severity bleed?
Burns in and of themselves don't typically bleed a lot. I mean, it tends to be more sort of, weeping and loss of fluid from, the skin, which kind of keeps us, what's in, and what's out of us. Once that's broken down, the fluid starts to leak out. But they don't really bleed per se, like a laceration or a gunshot or a stab wound would.
In your experience, if someone were on fire, would it be possible for them to run a short distance?
Yeah, I mean, there's nothing about being on fire that would immediately incapacitate you. Never been on fire myself, so I don't know. I've never seen anyone on fire, but I'm pretty sure that you could, and probably would, want to try to get away from the source of fire or get someone. Isn't that what they sort of teach you in school? Or at least they did when I was in school, don't run around like crazy because you'll just fan the flames and burn more, but you're supposed to, stop what you're doing and roll around on the ground.
Any other significant findings in this report that I have neglected to discuss other than the toxicology?
I don't think so. I mean, I think we've discussed, the injuries that were sustained in my opinion as to why he died.
So I'm going to have you flip to the toxicology page. So the last page, I'm going to have you flip to that one of the toxicology report.
Yep.
You got it. So can you describe for the jury what we're looking at here on the top there of this toxicology page?
I just want to make sure there's 2 pages to the toxicology report, so I just want to make sure I can read which one is up there. Sorry. My vision is
I believe
this the urine?
This is the analysis of the urine specimen.
Right.
revealed.
So both a blood and a urine specimen were tested by the toxicology laboratory. In the urine, there were 2 substances that were detected: hydrocodone and hydromorphone. Those are both opioid pain medications.
And are they connected together or are they separate substances?
They're very similar substances. Hydrocodone is a prescription painkiller, opioid pain medication that goes by a lot of different brand names. The pill form is oftentimes marketed as the brand names Vicodin or Norco. Hydromorphone is the major metabolite of hydrocodone. So if you take hydrocodone, your body then breaks it down to some extent, and one of the products that it forms is hydromorphone, which is also a pain medication. Hydromorphone can also be prescribed on its own as a separate pain medication, oftentimes under the brand name Dilaudid. But when I see both of them together, it is most commonly in the setting of someone who has taken hydrocodone and it's been metabolized and hydromorphone is present.
And were you aware then that in this particular instance that Mr. Stermer had been prescribed some medication for an ear infection?
18 years ago when I authored this report, I don't know if I knew that or not. I don't recall knowing that at the time, but there's been a lot of time that's passed between when I did the report, when I did the autopsy, and now. So I know I have subsequently been informed that he was prescribed a medication that contains hydrocodone.
Are you familiar with N-Tex HC?
Yeah, I know it's I think a liquid medication that contains hydrocodone as one of its components.
So when you say a liquid medication,
I think it's something that you would take, it's liquid, you pour it out, and you take it as like with a teaspoon, as opposed to like a tablet solid form.
are you familiar with a drug, I'm not going to pronounce this correctly, MECLIZINE?
Meclizine.
Meclizine. Are you familiar with meclizine?
I know what it is.
And what is it?
Meclizine is often, I think, sold as under the brand name Antivert. I think it's an antihistamine medication.
So you said N-Tex could possibly show then as the hydrocodone.
I think N-Tex has actually got more than one constituent to it. I think it's a liquid that has, as one component, hydrocodone. And so taking N-Tex could certainly result in the toxicology findings that we see in this case.
How about the meclizine? Would that show on a toxicology report?
With the testing that we currently do, yes, I do think it would. The testing that was done 18 years ago, I'm not sure.
So you would have had to test specifically for like an antihistamine?
Even if we would have tested for antihistamines, not all antihistamines are the same. I believe that the classes of drugs that were detected or that were screened for in the urine are listed on the report, and I don't think that antihistamines are listed. So I don't think it would have been detected on the toxicology screen of the urine that was.
So you had a standard panel that you tested for?
Yeah, at the time we submitted it to the lab. I don't know, what the name of the specimen or the panel would have been, but there were standard drug panels that were performed on blood and urine. Usually it was a little bit more comprehensive in the blood than it was in the urine. In the urine, based on the listing of drug classes here, antihistamines aren't listed, so I'm pretty certain it wouldn't have been detectable in the urine. Antihistamines were listed in the panel that was performed on the blood, but again, there are a large number of drugs that are listed as antihistamines, and I know some of the antihistamines that would have been detectable, things like diphenhydramine, which is Benadryl, are pretty commonly detected. I don't know if meclizine was listed as one of those that would have been detectable.
And you brought up then blood and urine screens, just in those that you're testifying. Can you explain the difference or what was done here or why it wasn't done here between the blood and the urine screens?
Why the testing was different?
Or can you explain the difference between urine testing and blood testing?
Like why a substance is in one but not in the other, or?
Yes.
Okay. So in this case, the hydrocodone and hydromorphone were detectable in the urine, but they weren't detected in the blood, and that is likely due to one of two reasons. So after a medication is taken, whether you ingest it or you inject it or however you actually take it, it will eventually end up in the bloodstream and will go to the organs and will exert its effects on the various organs. While this is happening, the body is also metabolizing it and getting rid of it, for lack of a better word. One way in which the body gets rid of drugs is to excrete them into the urine. And so it's not uncommon for us to do testing and see a substance both in the blood and in the urine. It's still present in the blood, it's being metabolized and excreted in the urine. After a while, most of it has been removed from the blood, but it's still present, being excreted by the kidneys into the urine. So in a case like this, it may just have been that he took it long enough in advance of his death that it was no longer detectable in the blood, but was still present in his urine. The fact that a substance isn't detected in a toxicology screen doesn't mean that it's absolutely not there at all. It just means that it's not there at a high enough concentration that the test can actually detect it. So that would be the other possibility as to why it's negative in the blood, but it's positive in the urine. It may have just been at a very low concentration, below the threshold of the testing.
If someone were to take any sort of medications or substance just a few hours before their death, would that be something that would routinely show up then in a toxicology report?
With a lot of caveats, the answer is yes. Most drugs, if you take them orally, have to be absorbed through the stomach or the intestine, so it takes a little while before they show up. Like if you take an aspirin, it doesn't immediately show up in your bloodstream. It takes probably at least some minutes for it to be absorbed. Yeah, I've lost my train of thought. What was the question again?
Just if somebody were to take something very short, like a small period before their death, would it show up in their blood?
Yeah, usually, as long as it wasn't just a minuscule amount of it. If you took something an hour before your blood was drawn, it would probably show up in the blood. If you took it 24 hours before, depending on the dosage, how much you took, and whether you were taking it daily up until that point, it may not show up in the blood, but probably show up in the urine. In this case, hydrocodone and hydromorphone have what are called half-lives of a few hours, meaning that once it's in the blood, it takes a couple of hours for it to be halved, and then another couple of hours for that half to be halved. So it would be present in the blood probably for a few hours, at least after you took it, but it might be present in the urine for hours or maybe even a couple of days after you last took a dose.
And I've put up on the screen then the blood results, and were there any findings in the blood results?
Yeah, the only thing that was detected in the blood was some caffeine. All of the other classes of drugs that were included in the testing panel were not detected.
And at the time in 2007 when you did the autopsy, did you test for THC or marijuana?
It looks like in the blood, cannabinoids, which are what class of drugs marijuana is in, they were included in the blood drug screen, and there were no cannabinoids detected.
And in your experience, do cannabinoids stay into the system longer than a few hours?
Yes, generally. Especially if you use marijuana regularly. Again, depending on how much you use, it may be present for hours, days, sometimes even in the urine for many days, if not weeks after you've stopped using it.
At the time in 2007, would you have tested for sleeping medications such as Ambien?
Again, since I don't do the testing, I can't tell you other than I don't know if Ambien would have been included in this panel in 2007. My guess is it probably would have been. I know that I've been at Sparrow, I've been at my current employer for 20-some years, and I know that we have seen cases with zolpidem going back many, many years. So I think it probably would have been detected if it was there above the threshold, but I can't say with certainty.
And in this case, there was nothing detected if you would have tested?
Yes.
How about muscle relaxants?
Again, some of the specific muscle relaxants probably would have been detected, but probably not all of them.
I think I failed to ask you, you have as the cause of death the thermal injuries, but how does someone actually die from a thermal injury?
Well, there's lots of different ways. I mean, people that die contemporaneously with the burn, so they don't survive. Many people survive burns and then die of complications, oftentimes infection and that sort of stuff once you've exposed the skin or the underlying tissues to the external. Many people end up with infections. Acutely, it's thought to be due to shock, probably due to loss of all of that skin surface. There's loss of body fluid, and so it tends to be sort of a shock situation where you lose fluid, you can't keep your blood pressure up, you can't perfuse your tissues like your brain and your heart and all of the organs that you need, and that results in your death. It may also be related to inhalational injuries. If you actually have heat-related injuries to the airways, you may actually develop some respiratory complications of those thermal injuries as well.
Any other significant findings that I failed to address in your report?
I don't think anything of significance.
I have no further questions, Your Honor.
I'm going to go, I don't know.
We return at 1:30 due to some other matters, but remember the rules, do not discuss the case with anyone, no social media, no research, no investigations. And, okay, well, Ms. Siderveen, would you mind? I think that was your exhibit. We'll retrieve the exhibit. Yes. Yep. Is that, did I say that right? Am I supposed to? No, he's still going to be here, right? Yeah, we're going to do the longer breakdown. Okay. Yep, he'll be back. Thank you. Right here?
Yeah.
Okay, you talked
I
to
talked to
them?
my messenger. I think it was him. I asked him, I think it was yesterday. I'd have to look at my messenger, but we talked to messenger, and then I looked it up this morning, and it said I had a bench warrant.
Okay, you messaged one of them, or?
Yeah.
Okay.
Yeah.
Counsel, since you happen to be here, defense counsel, Mr. Mueller, since you happen to be here, she's indicating she messaged you or Mr.
No,
Kelly?
Art. I think I talked to him on messenger.
Art?
Yeah.
That would be Linda's significant other.
Yeah.
Oh, okay.
So then I called this, or that's when I emailed this morning, when I called and found out, because I seen it online. I looked at it.
Okay. Okay. Are you on anyone's probation or parole right now?
No.
No? Okay. Anyone wish to be heard on,
Well, first of all, I have a concern about the defendant's significant other communicating with witnesses in this
Yeah.
case. He's not a party, he's not an attorney, he's not an investigator, he's a significant other, so that causes me grave concern here, Your Honor.
well, who contacted whom?
I reached out to them.
How did you find,
I think, go ahead. I think it was me that did it. I don't remember. I'd have to look at my phone and tell you for sure. Because to me, this wasn't really like that big, that significant. I think it was me that reached out to him. I don't remember. I'd have to look.
do you know them personally, or?
Well, I mean, right, but I had heard that the trial was going on and stuff, so.
But I want to know how she knows Ms. Stermer's new significant other, because they were neighbors in 2007.
No, but I talked to him plenty of times on Messenger. Previous, I think it was 2019 and 20. I talked to Linda and Art previously, like a long time ago.
Anyone else?
Just like a friendly, just talking.
About the case, right?
Yeah, we didn't talk too much about the case, but a little bit, in general, just like how Linda's well-being was and stuff, how she's doing since she got out.
Okay. How'd you get here today?
The deputy?
Deputy brought you? Okay. Okay, anyone wish to be heard?
Well, first of all, I'm going to ask the court to prohibit this individual from having any contact with the people's witnesses. He's not an attorney. He's not a private investigator. He should have no reason to speak with anyone. And if he wants to play a lawyer, he can go to law school. If he wants to play a private investigator, he can get his license. So this is extremely disturbing and frightening that this individual is having contact with our witnesses. Especially since there's no reports ever being prepared, there's no discovery of any of these conversations being provided. I'm very upset by this, Your Honor, and I'm kind of holding back as much as I can here because this is very frustrating. The other thing is, I think at this point in time, the court needs to arraign on a bench warrant. She was validly served with a subpoena. I'm in agreement that probably a bond should be set in this matter.
Any position?
Yeah, like I said, it's showboating right now, first of all.
Takes one to know one, sir.
Second of all, she inquired about Linda Stermer's well-being. They were friends and neighbors for years. There's nothing wrong with that. And in terms of anybody reaching out to anybody, it came from the witness to our side. So there's no issue here.
Ma'am, so what'd you say, you live in Grand Rapids?
I do.
Okay. Is there any way to get her on the stand today?
No, I have experts that have been waiting that I'm not going to be able to get on the stand today. So I'm not going to put her failure to appear on a timely fashion ahead of a priority of somebody who's in a professional career and is now going to have to come back. Your Honor, I would also inquire if she has reliable transportation.
I don't. No.
And I can say for the record, Your Honor, I wasn't paying attention, frankly, when she was talking about reaching out to somebody. I don't know when that happened. I contacted Ms. Calhoun a week and a half ago. She hadn't been served. And I just wanted to know, have you been served? Are you going to come? So I have to subpoena you. And do you remember what you said in your affidavit? Because I'm going to ask you questions about it. So that's the only and I don't know if she's confusing Mr. Bean with me, but that's my contact.
Ms. Calhoun, do you have any controlled substances in your system now?
No, I don't. No.
Methamphetamine by chance?
No.
Okay, what I'm going to do is I am going to set this matter for a status conference for Tuesday. Say 1 o'clock. Do you think you can get her on the stand?
I could try to make adjustments so that she could be on the stand.
Okay. I'll set the matter for Tuesday at 1 o'clock for a status conference. And ma'am, due to your failure to appear here, I am concerned at this time about non-appearance when I hear about the transportation issues as well, so I am going to set a bond.
Okay. I have, my brother lives in Lawrence. I can live or stay in Lawrence.
Okay.
That's okay.
Well, for now, I'm going to set bond. I'm going to make it $1,000 cash or surety.
Oh my gosh.
Okay, to make
I'm
sure that you show for the year on time for your, under your subpoena. Sounds like both sides were inquiring about using you and you didn't show.
It wasn't because I didn't, I was unaware that I was needed, right? I mean, like, honestly, I've had some stuff going on in my life that I didn't even, like, my own problems.
Okay.
You know, not that this
Yeah.
isn't a big problem, but my own issues, like serious issues. And I wouldn't just miss something because I didn't want to be disrespectful or just because I was being disrespectful to the court. I had no idea, like,
Your Honor, not nothing, but our subpoena was for April 7th, because that's when we anticipate starting. So it wasn't like she missed our subpoena. or
Miss
whatever.
yours, okay. I am setting a bond, but the reason it's not too high, ma'am, is because we were able to get you here, but we had to get someone to get you here.
I don't have a car.
Okay, okay. We'll have to figure out a way for transport then, okay? If you post that bond. Okay? Okay?
It's fair over somebody else's problems. My own life and my own problems.
Okay. Ma'am, I'm going to have you tested at the jail, okay? Anything else, anyone? Ma'am, if you do post that bond... Okay. If you're able to post the bond either directly or through other people, you need to report back here on April 1st at 1 o'clock, okay?
I don't have a car.
Okay. Okay. Well, make sure you're in contact with the lawyers so that they can contact you. If you don't post it, they'll contact you at the jail, okay?
It's not fair.
Okay. Okay, thank you. Anything else, anyone, on that matter?
You did order testing in the jail.
Yeah, I ordered that. I have her tested at the jail.
Are we addressing the issue of this art person speaking with witnesses, Your Honor?
I don't know who he is. Is he here?
He's here in the courtroom. I've seen
Okay.
him every day.
Where is he?
I believe it's the gentleman back there in the blue shirt, Your Honor.
Sir, yeah, are you having any contact with witnesses in this case?
Back some time ago, I contacted her to find out an address on her and a telephone number, but obviously that changed because Wolf had it on a subpoena for her, and they wasn't able to. And she messaged me yesterday and said that she found out the cops were looking for her, and I said, yeah, because they issued a bench warrant for you.
Okay.
That's the extent of our conversation.
Sir, I'm directing from now going forward, no contact with witnesses, okay? Is he part of the defense team, or is he a boyfriend of Ms. Stermer or significant other?
He's been helping our defense team with legal issues.
Okay, I don't see, is he a significant other of Ms. Stermer?
Pardon me?
Is he a significant other
Yes.
of Ms. Stermer?
Yes.
Okay. I'm going to order that he have no contact
No
with
problem.
witnesses due to the commingling there of roles. So to keep it clean, no contact with witnesses, sir.
Done.
You
I
understand?
did bring it up with Mr. Kelly yesterday. I informed him that she contacted me.
Okay.
And I told him not to contact her.
Okay.
Yeah, I mean, so we've already took care of that, but I did inform.
I can't change what the past, but going forward, zero contact, okay? Thank
I
you.
didn't reach out to her just
Okay.
in the beginning for a phone.
Okay. Okay. Anything else, anyone?
Just, we want to make sure it's on all witnesses.
Yes.
Because obviously he had her contact information, he's spoken to her in the past. It's not just her, we're asking on all witnesses that he does not contact any of them. Thank you.
Okay. Anything else, anyone?
No, Your Honor.
Okay, thank you.
charcoal strip, activated carbon strip that we used for sampling each of the samples.
And so those are the actual samples that would have been put into the gas chromatograph?
That's correct.
And obviously you're aware at some point in time, you worked for Barker and Herbert Laboratories, is that correct?
At one time I did. I retired in 2017, June of 2017.
And if you have knowledge of this, I don't know, does Barker and Herbert have a file retention policy in place?
They tell me they only had to hold the files 10 years.
And so that would have been from the date of your testing in 2007 until roughly around the time you retired in 2017?
Yes.
And they would have destroyed their in-house file, is that correct?
That's correct.
And what information was contained in that in-house file?
Would have had the chromatograms. There would have been a continuity from Mr. Shinsky. There would have been a return postal card showing the number and the address going to Mr. Shinsky when we returned the samples. There would have been any notes would have been on the chromatograms. Near as I can recall, that covers most of it.
Okay. So essentially, if I could boil it down, it'd be kind of like we have some information that's related to chain of custody of the evidence, is that correct?
That's correct.
And then we have the chromatograms, which are essentially just the printouts from the machine, is that right?
Yes.
But those printouts actually require your interpretation, is that correct?
That is correct.
And you had to review those in order then to memorialize them in your report.
Yes.
And the findings of those chromatograms are in fact memorialized in the report that you have been provided and you have reviewed, is that correct?
That is correct, yes.
Okay, all right. Just a moment, Your Honor. Okay, I have no further questions.
Thank you. Mr. Mueller?
Good morning, or afternoon, Mr. Balliet. How are you?
It goes fast when you're having fun. I'm doing well, thank you.
Good, good. You've been retired now for 8 years, roughly?
Almost 8 years.
Okay. Make sure I get this good. All right, let's talk about, just real quick, your career. How many of these chemical tests, these analyses, this gas chromatograph, mass spectrometry, GCMS tests have you run in your career?
Well, I've been doing it had been doing it for 35 years.
Clearly thousands.
I'm going to give a wild guess right now, in excess of 50,000, somewhere between 50,000 and 100,000. That will include also the standards, the system checks that we run with samples. Will also include clean. Got to think of the words. Clean vials with solvent in them, the carbon disulfide checks.
Even looking at this, do you remember this test specifically?
Do I remember this test specifically?
Yes.
All I can say is that I testified on it once, and
other than that, you have no recollection, do you?
I remember the red towels. I remember testifying.
Okay. Let's talk about how you go about finding your conclusions, okay? First of all, I want to show you what, and this is part of the supplemental brief and part of the objections, Your Honor. Exhibit number 1 was the test on the red towel. You have that in front of you? I can give it to you.
I do. I have a copy of it.
That's your test, right? And what happens in this test is you put down the results of testing, am I right?
That's correct.
The results of the testing was test on extractions from the samples revealed gasoline residue present on sample 2A and sample 2B. You see that?
I see it.
And then we know from the inventory of samples, we're talking about basically the red towel from the laundry, from the washer, right?
Yes.
And the red towel from the item number 2 bag of laundry, right?
Yes.
And when you do this, you run it through this GCMS machine, right?
Well, there's procedure done before we ever get to the GCM.
You got a lot of procedures you have to do.
That's correct.
And then you have to make sure you document those procedures,
That's correct.
right? Just part of the scientific method, the documentation,
That's
fair?
correct.
Then you get the results on all these charts, am I right?
That's correct.
All right, I'm going to show you, and I'm going to hand to you, Your Honor, just a report from Troy Ernst. You know who Troy Ernst is, by any chance?
I beg your pardon?
Troy Ernst?
I do not know Troy Ernst, no.
You tell me, this is a report from Troy Ernst. He did a GCMS test on some sweatpants, and he generated a report. And what I want to do is talk to you about the report he generated and what those charts are. First of all, we know, because I subpoenaed your office, exhibit number 2, that your office has no more records, am I right?
That's what they have told me. I've been there and looked, and I have not found it either.
Okay. So, if we go to Mr. Ernst's report, are those the kind of charts we're seeing up on the screen that are typical of this GCMS machine, this
Yes.
testing?
Those are chromatograms. I don't know what instrument that is.
Okay, but that's what you were telling us about, right?
Yes.
That's what generated. You actually have to interpret those, don't you?
That's correct.
I mean, it doesn't come up with an emoji, thumbs up, positive, does it?
Don't have one.
Thumbs down, negative, does
Don't
it?
have one of those either.
Or red light, no substances, right? Green light, positive. You have to do that, right?
That's correct.
It takes your intelligence and training.
That's correct.
And you don't know what those charts said on this particular test, do you?
On which test?
On the test of the red towels. All you're doing is reading your conclusions. Am I right?
I don't know which test you're asking about.
Listen to me very carefully.
The test for the red towels.
The test that I had done or the test that Michigan did?
I'm going to take
I
the
think he's
Michigan State
asking you
one
about.
back.
Good
yeah,
choice.
Yeah, I think he's talking about
Thank
the
you.
one you did.
We're going to talk about your testing on the towels. Are we clear?
Okay.
On the testing on the towels, you had charts very similar to the 39 pages of chromatograms we have here, right?
I don't know how many he had, but we had chromatograms and we had ion chromatograms,
Okay.
breakdown of the particular piece.
Okay. So the bottom line is you have to interpret all of that, right?
That's correct.
And that's how you come to your conclusion there was positive for gasoline on those 2 samples.
That's correct.
And without that, right now, you don't know what caused the positive.
In order to make the determination, we use overlays because we are required by ASTM, the procedure we use, to make visual comparison with known ignitable liquids to be able to make that determination.
You don't have those visible comparisons, do you?
I do not have them.
You have no records or what we call data. That's called underlying
I do not have the
data.
data for the case.
Let me finish.
He's testifying. This has got to
This is
stop.
cross-exam. And he
don't get to
can
testify
say the argument for the jury.
Both of you, this showmanship you're both doing needs to end, and the drama needs to end now. So please, don't even start asking a question, Mr. Mueller. I'm not done, okay? Give me a minute. This witness is just here because, through no fault of his own, documents were destroyed. We have a legal ruling. There's no reason to be getting emotional with this witness or for any other reason.
Mr. Balliet, you don't have what we call the underlying data to support your opinion, do you?
I do not have it with me because it does not exist.
Because it doesn't exist. And if you don't have that, you don't know what interpretation you made 18 years ago that led you to that conclusion, do you?
Well, do you have to assume then I'm either lying then or I'm lying now?
I'm not assuming anything,
Either
sir.
time, sir.
I'm just asking, you don't have the data, so you'd just be reading that.
You've asked that a number of times, and I've said I do not have the data.
So you would just be reading the conclusions. Fair?
Yes.
No more questions. Thank you.
That report you have in front of you details the process and procedure you used. Is that correct?
It identifies the procedures, yes.
And you are still to this day intimately familiar with those processes and procedures, correct?
I am, yes.
And you took the results of those chromatograms, and the point, I guess let me ask you this way, the point of writing that report is to memorialize the data that you observed in your findings, is that correct?
That, and to let the client, and in this case Mr. Shinsky, know that something was identified in some of his samples that we qualified or identified as gasoline residue.
And even in that report, you don't quantify a level of gasoline or anything.
We do
correct?
not.
You are just indicating that there is the presence of gasoline.
That's correct.
And so basically all this chromatograph, the GCMS does is simply identify that the substance is present. Is that a fair statement?
That is a fair statement, yes.
And then you take that it's there and then put it on your report basically saying, I found gas.
We say we found gasoline residue.
Or gasoline residue.
Yes.
Right, I'm summarizing, but that is essentially, the purpose of your report is to memorialize all of your findings.
That is correct.
And you've testified, you said, or you've had, I'm sorry, not testified, strike that. Somewhere between 50 and 100,000 cases you've analyzed.
I'd have to figure out how many I have done over 35 years. Right off, I do not know.
Fair. But the whole point of that report is to be able to refresh your recollection should you be called to testify in court. Is that fair?
Yes.
Thank you. No further questions.
Just a few more. So you do know the difference between underlying data and methods and procedures?
I do.
Okay. There is a significant difference, isn't there?
There is.
The method you're talking about is we use this MSGC and we prepare it, and you describe those methods, right?
I identified the methods in the report.
Right. But you can't identify the underlying facts and data that you interpreted to get to the result, right?
I'm going to object, Your Honor. This has been asked and answered. I think he's asked it ad nauseum. Last time he's asked
No.
it again.
Because I can follow up.
One more time.
Okay. And because you don't have the underlying data, it would be unfair for me to try to question you because I don't have the underlying data. Do you agree?
Well, would you have used the underlying data previously?
Can I get an answer to my question? If I don't have...
So I'll have you move on.
Okay. I don't have anything more for you. Thank you.
Thank you. Sir, would you normally, did you find out about this, that the records had been destroyed? Did you reach out to the company where you worked to get those for purposes of testifying?
Yes, I had received a subpoena sometime in 2024. I think the case was going to go around 2021 also, but I did not get any subpoenas at that time. In 2024, I had gotten a subpoena, so I contacted the company to be certain that I could get a copy of the report. Normally what I would do would be to go over to the laboratory and do the copying myself so that I had everything that I was going to need for testimony. And they indicated to me at that time that the case no longer existed. So when it was destroyed, I have no idea. But they informed me that they only keep them for 10 years.
And I'm not a science person, so you'll have to forgive my naivete on my questions, but would you normally, there was the graph that was put up, would that be something normally was that part of the data that you used to reach your ultimate conclusion that there was gas involved? The
chromatogram that was shown on the screen is similar to what we would have had. We have I'll call them charts, but they're charts of chromatograms, and with GC mass spec on those charts, and you notice there were peaks and valleys. Yeah. On those peaks and valleys, we can go in to the computer, ask the computer to tell us what are the ions that make up this particular peak, and then that's the mass spectrometry part. The ions are indicative of what makes each of those peaks, and the ions are all going to be different for each of the peaks. That's what I would have had in the file. Yes, all of the
produced at a hearing or something. You normally have that.
I always have it with me. very seldom in testifying over 35 years have I ever had to show it to the jury. I can think of one case. There was one case in Michigan that the attorney wanted me to show the jurors the chromatograms. They made copies of all the chromatograms and the extracted the ion sheets of the components, and the jurors looked at them and were able to come to the same conclusion that I had reached by using plastic overlays that I had supplied.
So you look at that with the word I can't pronounce, and then you make an interpretation off of that data of, in this case, gasoline on an item. That's the data, that graph that we saw, or something like that from Ernst. Something similar to that would be what you would normally, that's what you're looking at, and then with your expertise, you look at that data and reach a certain conclusion.
Well, the reason I mentioned the chromatograms that we had provided to the jury in this other case was because they were able to take the overlays, the plastic overlays, and put them, plastic overlays being of known ignitable liquid residue. I think that case was also gasoline, but they were able to take those overlays and put them on the chromatograms that I had done and make the comparison, and that's exactly what I would do. It's got to be straightforward enough that it's identifiable to even those that would be serving on the jury.
So in this case, the jury wouldn't be able to do that, though, right? Because we don't have it.
We don't have the data that does not exist.
Just looking through my notes there. Anything else, counsel?
When ordinarily you give your information to the requesting party, so in this case the insurance company who requests you test these items, do you send those chromatograms to them as well?
No, not unless they would ask for them, and I don't recall ever having an insurance company ask. Many times after litigation starts, one side or the other will like those chromatograms. They want copies of those chromatograms, but generally we do not send them directly to the insurance company because they have no idea what they're looking at. So,
thank you.
So is that the entirety of what, I know you don't recall reaching your conclusions in this case. You have your report of the conclusion, but this graph document you're describing, is that the totality of what data you would, or facts that you would have used to form your opinion that there was gas?
yes, it's based on gas chromatography.
It's based on that, and in this particular case, the results of the gas chromatography.
Gas chromatography coupled with mass spectrometry.
Okay.
That's
Did they destroy that data too?
It's gone.
The second one?
Yeah, it's gone.
And those are the pieces of data you used to reach your conclusion here?
Yes.
Okay. Anything else, counsel?
You want legal argument?
So first, I want to see if anyone has any more questions of him.
I know, no.
As far as you know, sir, that underlying data is gone forever, best of your knowledge.
The file that I had asked for at the laboratory no longer exists.
Thank you.
Go for it.
Okay. Brief arguments, counsel?
Your Honor, this isn't even a close call. MRE 703 specifically states the facts and data in the particular case which an expert bases an opinion or inference shall be in evidence. The use of the word shall indicates a mandatory imperative directive, and that's Burton versus Reeves City Hospital Corp. 471 Mich. 745 at 752. That's a 2005 Supreme Court case. The other case that talks about it, it necessarily follows that an expert witness may not base his or her testimony on facts that are not in evidence. People versus Unger, 278 Mishap, 210 at 248. That's a 2008 Court of Appeals case. We do not have the evidence. He has to have that to interpret to get to those conclusions of a positive gas test. And why do we require that in MRE 703? Because, as the Supreme Court stated in People versus Kowalski, 492 Mish 106 at 121 in 2012, expert testimony without a credible foundation of scientific data, principles, and methodologies is unreliable and thus unhelpful to the trier of fact. Not even a close call. People versus Fackelman stated that an expert's opinion must be based exclusively on evidence that has been introduced into evidence.
Okay. Thank you. Mr. Blair?
The issue with every case that opposing counsel decided is those are all analyzed within the concept of the confrontation clause. The confrontation clause requires that a testifying scientist that prepared the report be present in court to testify. Obviously, he's here. He did the entire process, so the confrontation clause is not what's issued here. What it seems to me in reading that, first of all, it's facts or data, not facts and data. They're mutually exclusive with one another. So the facts are present here in court today. He's here to testify. The jury, I think, should be able to, Mr. Mueller can cross-examine him about the lack of the chromatograms. I don't think it renders his opinion and findings unreliable. He can question.
703 is really clear. Your witness seems to be testifying as credibly as he can. It's not his fault that evidence got destroyed, but his opinion was based on these two different manners of whatever you call them, but we don't have those. I mean, how are you getting around 703 here?
Because it's memorialized in a report.
That's the conclusion. The report is his conclusion. And so we're looking for the data supporting his report, which normally we would have, but by, a very unfortunate, no one's fault,
I understand that, Your Honor. I still think it goes to weight, not admissibility. He is a qualifying scientist. He is able to testify about the procedures that was used, what he did, and the results. But I think it goes to weight, not admissibility. I think it's admissible. I think he should be allowed to testify in his report. The jury can give whatever weight it wants. Mr. Mueller can cross-examine him ad nauseum about the fact that those chromatograms are missing and he can't do his own independent comparisons of the chromatograms and so on and so forth. But at least the report should still come into evidence. I think it's a valid record of everything that was done, and he can at least admit the report, and the jury can give it whatever weight they want to decide it belongs to it at this point in time. If they want to give it no weight because the chromatograms are not here, fine. But they can give it whatever weight they feel or they deem is appropriate. The foundation of him being an expert is not in question. The methodology he used is not in question. And his findings are still present. And I think that's important. And he can testify about the process that was used and how those chromatograms would be reviewed in arriving at his conduct, at his final results. Just because those chromatograms aren't here doesn't mean that those results should not be available.
Where do you see that in 703? Because I'm reading the opposite. That his opinion is based, he said, on two different things, neither of which we have. And the evidence in the particular case, or facts or data of a particular case must be in evidence.
Facts or data.
Facts or data.
Facts. We've got the facts. He's testifying as a fact witness. He is testifying to facts.
So he's not going to give his opinion about it?
Well, no, that's in his report. What I'm saying is he's giving facts about what he observed and facts that he saw. It says facts or data.
Because I don't understand that. He said again, I'm not a scientist, but he said his conclusion is based upon these graphs that he does, and he doesn't have the graphs.
I understand that, Your Honor. That's been beaten down here ad nauseum. I completely understand these graphs are missing. If I had them, boy, I'd really like to have them and save us all this 11th hour challenge to our evidence again in the middle of a trial. So, the problem with this issue is, Your Honor, there aren't really any specific cases that directly address what's going on here. Mm-hmm. This is kind of a novel issue. I did research last night. I think I at least supplied law to the court at 9:30 last night, of which the defense has supplied none. at 9:30 last night, basically trying to find something that would support this. I can't find anything. Because chromatograms apparently are something that no one cares about when an expert's rendering an opinion. And so that's, I think that maybe is somewhat telling about this issue, is that it's not necessarily it goes to the weight, not the admissibility. It's not necessarily the underlying data. That doesn't necessarily supply the entirety of the underlying data, I should say, that the court needs to render a decision.
Okay, well, first off, I don't believe that this is a confrontation issue. I don't believe a machine makes testimonial statements, so we don't have to go there. But try as I may, after listening to this testimony today, I can't get around 703, which leaves the court without discretion. And the court is obliged to, and I quote, "An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. The facts or data must be in evidence or, in the court's discretion, be admitted in evidence later." He's identified two sets of, whether you want to call them facts or data, that he's put into evidence or that he reviewed that form the basis for his opinion. Through no fault of anybody here, the company destroyed that data, so we don't have it, which leaves the defense without the opportunity, apparently according to the rule of evidence here, to effectively cross-examine. I don't know that there's nothing in the rule that leads me to believe that this is in fact an issue of weight. Witness has been very clear. That's what he interpreted. That's what he had, but we don't have it here today. So I'm going to exclude the evidence.
May I suggest one other avenue, Your Honor?
Okay.
Could we admit the record as a business record, just not have him testify to the interpretations and his findings? I believe it would be a document kept in the regular course of business at Parker Analytical Laboratories. It could come in as a business record. However, he's not allowed to give us any expert testimony about what he did. He can simply admit the record. Jury can give it whatever way they decide.
Your Honor, that's absurd. He's the expert who's going to testify that the gasoline was positive on the red towels. To try to backdoor this in where he's not even allowed to testify, but you can read to this document to the jury. Come on. We've supplied. I'm not even belabor the point. Thank you.
I mean, Mr. Blair, that would require some research. I'm not going to go on the fly on that right now, but...
Well, then I'm going to ask the court to at least enter an order that Mr. Valliott's not to be referenced by the defense in their closing argument, in any arguments, or the red towels, or anything along those lines should not be mentioned by the defense, because I've heard comment earlier about how if we don't present certain evidence, it's going to be, and I quote, rammed down our throat. So I don't necessarily want that, this to be brought up. I think that's fair and appropriate given how this has played out.
Your Honor, how many cases have you tried? Somebody, one party gets up and makes promises to the jury in opening statement.
Yeah, I think it's fair to say,
Absolutely.
to comment on what wasn't done in a case, or but if he says it wasn't done, that's one thing, because that would open the door to, that's dishonest, because it was done, but just that the jury would see
it. Comes up in a closing argument, and the problem is we made no promises about what the jury was going to hear from Mr. Valliott.
Right.
So it seems only fair given how this has played out in court. There's a fundamental fairness issue here as well, that it seems to be falling on its face.
Really, Mr. Blair? Because you keep presenting this as this last-minute issue. This is your evidence. You're the proponent of the evidence. If you go back and look at the transcript of this matter in 2021, we discussed all of this. And I said, assuming the prosecutor can lay the foundation, I'll allow it in. So you've been on notice. I've been on notice. We're all on notice. It's a rule of evidence. It's a standard rule we have to follow. That's my ruling. So I don't know where this is about fundamental fairness. If the it happens in every criminal case where the defense highlights what evidence you didn't hear. And so if they want to say you didn't hear any evidence of the towels, that's fine. Now, obviously, if they go on and say the prosecution never had them tested or something like that, that would be completely inappropriate. But to highlight for a jury evidence that they don't hear in a case happens all the time.
Well, essentially, if they get up there and say, you didn't hear from the testimony of Craig Balliet, well, you've excluded it, so it leaves us in a kind of an unattainable position. I guess that's where I'm kind of going with this. Is
Well, I guess what we could do is when we get to that part, you can provide me in advance of what you intend to say to the jury, and we can go from there, if it's as it relates to Balliet.
Each other's playbooks out.
Okay, well, then I could just order that you not bring it up. I mean, that's what you'd rather.
If that's the
I mean,
alternative, we'll make an outline, Your Honor. Thank
Yeah,
you.
that's all I'm asking. Is
Yeah,
that
no,
we're
I
not
get-
commenting on a witness that wasn't allowed to testify
Right, okay.
by court order.
No, I get that.
I mean, that only seems fair.
That would be fair if it's because you couldn't lay the foundation for the exhibit
Well-
and the opinion.
Let's worry about the closing arguments later.
Thank you.
Okay.
And Ms. Balliet, if I was a little chippy with you, apologize.
Anything else then, counsel, before we?
I do have one issue, Your Honor. So if the defense brings up any testimony that Ms. Stermer smelt or had Mr. Todd Stermer was down there bleeding this furnace, which is obviously not the fuel oil that was found on those towels, it could come in as impeachment evidence.
No, I mean, I think there may come a point where impeachment evidence could come in. I
Yeah,
mean,
so
I have to hear it.
if defense presents witnesses that are going to
someone-
say
yeah.
that that Todd was down there bleeding the furnace, and if defense starts then putting the fact that there was this fuel oil that was on this rags and she was down doing laundry, I certainly think that at that point we need to revisit this for impeachment evidence, and then we would ask to admit it under a business record, as I've already brought in Mr. Balliet from out of town. So I just want to put everybody on notice. I mean, you can't then go ahead and start arguing after the court's excluded it that that's what happened when we have obvious knowledge that that's not what occurred.
Defense, just be on notice that you may open the door to this coming in as
All
impeachment.
right, but I want this for the record. There can be no opinion for any purpose that he hasn't laid the foundation to say what he did. To try to get some record in under the business record exception for impeachment purposes where there's no evidence of what he did, how he got there, is absolutely, it's inconsistent with the rules. That's not what that's for. You have to lay the foundation for any expert opinion.
Right now, we're here on the 703 issue. I've ruled on that, and so we'll have to just play other things out as we go.
Thank you.
I just want to make the court aware that we would intend to admit it under impeachment evidence then. Okay. Thank you.
Anything else, counsel, before we bring in the jury?
But I only have one question, Judge. If she's talking about, when you talking about impeachment, like bringing Mr. Balliet back in on the witness stand?
I don't know if I'm addressing him or you, Your Honor. We would have to address that path. If they're going to put witnesses up on the stand, or Ms. Stermer's going to take the stand and says, I smell fuel oil, and I washed it, and Mr. Todd Stermer was working on the furnace the night before, then I think we have the opportunity, the door has been opened, where then we would be able to then cross-examine and bring that in as impeachment evidence and say, isn't it true that that tested positive for gasoline and not fuel oil? That's all I'm saying. I'm going to be asking for Mr. Balliet to be released on subpoena. So I don't intend to bring him back unless the court were to direct me or order me to bring him back if we need him for that impeachment evidence.
How about if we get there, someone get me some law on whether the evidence that's been excluded under 703 can then be brought in for impeachment? I don't know. I haven't done that.
The only way they would try to do that is to backdoor it in through Jim Shinsky, who then they're going to read question and answer about his interview relating to that. All of this stuff now, given his opinion, as I put in my objections to their exhibits, is irrelevant. The red towels are irrelevant. His CV is irrelevant. His appearance is irrelevant. The red towels have nothing to do with this case, given that you can't connect it to gasoline.
I'm not here to rule on the red towels right now. I'm here to rule on the 703, which I've done. So
it's the opinion about the red towels.
They might have some reason to introduce the red towels. I don't know.
Give me a second here to clean up.
So may I let Mr. Balliet
Yes.
off of the subpoena and make you leave then?
Yes.
Okay.
Back, Terry. And Dr. Markey, you're reminded that you're still under oath. Thank you. Mr. Mueller?
Thank you. Good afternoon, Dr. Markey.
Afternoon.
You and I have never met, but we've talked a couple times on the phone, right?
Yes.
And I think we even did a Zoom at one point. Remember that during COVID?
Yes.
I'm going to ask you a lot of questions today about your autopsy report and the results, okay?
Okay.
I want to just first begin with, if I can, something I made a note of. You said when the body came to you, it comes in a sealed body bag, right?
Typically they do. I don't recall if this one was or not. I'd have to look at my report.
But the reason it's sealed, you said it's important that it's sealed, right?
I mean, generally they're sealed so that when I open the body bag, I know that there's nothing that has happened to the body since it was put in the bag until it was opened.
Right. Important for chain of custody issues, isn't that right?
Generally, that would be the reason.
Okay, because as a forensic scientist, as a forensic pathologist, you know you're in court and you have to establish a clear record of this was the body at the scene and the evidence with it, right?
Yes, I mean, that's essentially the reason, as I stated before.
And then when it gets to you, you open the bag and we can make sure that what was at point A is at point B.
That would be the reasoning, yes.
That's why you document what's at point B when it gets to you. Am I right?
That is correct.
All right. Do you know typically if the medical examiner's office has a policy, like where you work, you do things for autopsies for different counties, don't you?
That is correct.
Right. Where the MA's office has procedures and policies where evidence can't be removed from the body unless the medical examiner's office signs off on it.
Yes, in the counties where I serve as the medical examiner, the body is my jurisdiction, and anything that's on the body is my jurisdiction at the scene. And if something needs to be removed for some reason at the scene, then generally it is done at my office's authority.
And you would have a paper trail because you don't want critical evidence disappearing later on, fair?
I'm not sure. I mean, it would be documented in our report if there was something at the scene that was removed that was thought to be significant.
Okay. You don't have any record of anything being removed at this point, in this case?
I wasn't the medical examiner in this case, so I'm not responsible for that. I was just asked to do an autopsy and give an opinion to the Van Buren County Medical Examiner's Office.
Okay, so let's talk about these opinions. I want to talk about, obviously, the data you had included there was a fire and Mr. Todd Stermer was severely burned and ultimately perished. Fair?
Yes. I mean, I'm sure it was more detailed than that, but that was 18 years ago. I don't recall all of the details.
Then the next piece of data you had was there was some evidence that he had been run over by a car.
Yes.
Specifically a van.
Yes.
Did you know it was a Ford Econoline van from 1993?
I don't recall knowing the specifics.
All right. And the body then gets to you, and you talked about the thermal injuries, and we'll talk about that in a minute, but I want to focus right now on what you call the blunt force trauma injuries. And I want to go to your report, if we may. Can you see that?
Yes.
And you have your report in front of you, right?
Yes.
First thing you had was lacerations, you said, right?
Yes.
All right. Those lacerations were to the top and the side of the head, correct?
To the top, to each side of the head, and one to the back of the head.
If I say BFT, blunt force trauma, fair?
Sure.
So when we have 4 lacerations, right?
Yes. Yeah, that's what the report indicates.
One to the top, right?
Correct.
One on each side of the head, on the ears, you said?
They were on the side. One was on the left side of the head, above the level of the ear. The other was on the right side of the head, above the level of the ear.
One's on the right, one on the right side. And where was the last one, on the back of the head?
Yes.
So I put those down correctly?
I can't see
Oh, counsel's in the way.
it. Yes.
All right. Then we had, I think, linear abrasions, right?
Yes.
And you described those skin burns, you know, like you fell on the pavement.
I think I specifically stated that they were like scratches or scrapes on the skin.
Okay. And 3, we had rib fractures, right?
There are rib fractures, yes. 3 rib fractures.
2 on the left side.
Correct.
They were ribs 3 and 4.
Correct.
1 on the right side.
That is correct.
And that's rib 4.
It was rib 3.
3. Okay. Those were the only blunt force trauma injuries you saw, right?
No, as is listed in my report, letter C, there were lacerations on the right shoulder and upper back, left
Forgot
upper
that.
arm, and lateral left back slash chest.
Okay. So lacerations to the back and chest, or just the back?
To the back, to the left upper arm, and to the lateral left chest or back. It was on the side of his torso, depending on what you wanted to call it. It was either his lateral chest or his lateral back.
Okay. Now, those lacerations to the head, you said, those 4 were, I believe and it's in your report, I believe it's called minimally depressed?
No, the minimally depressed injuries were fractures of the skull. The lacerations of the skin were just splits.
No, I apologize. They missed. Skull fractures we missed, right?
Yes.
All right. Those 2 skull fractures were minimally depressed, right?
Yes, that means they were sort of, I don't even think I called them fractures per se, because they weren't like full breaks through the bone. It was just the outer surface of the bone was inwardly dented, for lack of a better word.
I've been told by other doctors, medical examiners, a depressed skull fracture can be described as if you took your finger and threw some icing on a cake a little bit. That'd be about right?
I mean, it's basically it's just a dent.
Right.
It's an invagination of the surface.
Those skull fractures certainly were not life-threatening, were they?
Those fractures in and of themselves, no.
Okay. Those 4 lacerations, and by the way, those skull fractures you say didn't penetrate the skull, and we didn't have any brain damage, did we?
No, there was no obvious injury to the brain.
Okay. In terms of other organs, there was no obvious injury to the heart. You would have noted that.
No, there's no heart injury.
There are no obvious injuries to the internal organs of the gut, liver, spleen, kidneys, nothing.
That is correct.
Okay. So we don't have organ injuries. In terms of fractures, you described these 2 minor fractures. We don't have any other fractures, do we?
There's fractures of the skull and then fractures of the ribs.
We'll talk the ribs. You said at least the ones on the left for sure are consistent with what you find when people are doing CPR.
Yes, they could be due to CPR.
Okay. And even you said it's uncommon, the one on the right, but you can't rule out that it could have been done by CPR. Fair?
That would have been very unlikely that a posterior rib fracture would be from CPR.
Let's say the one that wasn't done by CPR was caused by impact with a vehicle. That's not life-threatening, is it?
No, that fracture in and of itself would not have been life-threatening.
The lacerations to the back and the upper left arm, those weren't life-threatening, were they?
Unlikely. I mean, lacerations, especially of the scalp, and they can bleed. So if they're not attended to, they could bleed enough that you could lose blood, and it could be significant. But of themselves, they're not usually, immediately or significantly morbid.
Okay. So I'm going to go look at these lacerations because I was told you took autopsy pictures, didn't you?
Yes.
All right.
I didn't. They were taken at my direction by an assistant during the autopsy.
Okay. Give me a second. I'm going to show you a few autopsy pictures that have already been labeled as Exhibit H in ours. They're coming from your autopsy. You do take pictures as a standard part of autopsies, right?
Yes, during autopsies we take general photographs of the body and then photographs of anything that we think is significant.
I'm going to describe them right now.
Okay, you're not going to show them though?
I'm going to show him if he says he took pictures.
Okay, I just want to make sure, and then, I want to make sure you don't show them.
Our foundation needs to be laid. He said he did not take pictures. So I think the foundation needs to be laid that these are in fact pictures taken or...
I'm going to show him, if you don't mind. I'm going to approach. You've seen pictures of the autopsy?
Yes.
H1 is the head.
Yes, that is a picture of the head that was taken during my autopsy.
Okay. H2 picture, what does that describe?
Yeah, those are the abrasions on one of the arms.
Okay. H3 shows some what?
I think it's specifically meant to show the lacerations on the left upper arm and the lateral left chest.
Taken during your autopsy?
Yes.
And 4?
That's a picture of the back of the decedent, and you can actually see the laceration on the right upper back of the shoulder area.
Taken at your autopsy?
Yes.
Your Honor, I move for the admission of Exhibit H1 to 4, 1.1 to 4.
Your Honor, we don't have copies of these. I'm not really sure what he's admitting. I mean, I'm sure I have the copies of the autopsy, but I don't know what he's admitting. Is he admitting this as digital to the jury? Is he admitting these as copies to the jury? I'd like a copy of what he's admitting.
Your Honor, they were Dropboxed my exhibits 3 weeks ago.
What are you admitting to the jury?
The 4 pictures of the autopsy.
Are you making hard copies of them?
I have an extra set right here, but I've Dropboxed them to them.
Okay, let's let the prosecutor see them.
If they're part of his Dropbox, I've seen them. I just didn't have them here to see which ones he's admitting.
So your plan is to provide a hard copy for the jury?
No, it's yes, as the jury exhibit.
The jury room?
Yes.
Okay, so it sounds like he's laid the foundation. They're a fair and accurate representation of the autopsy photos.
Thank you.
Yes, they are some of the autopsy.
Counsel, are these? Yes, sir?
No, unfortunately it doesn't on this apple here, so I'll try to blow it up on the big screen.
Can I, Counsel, can you approach it so we can talk about the nature of the photos? To produce the photographs, I'll alert you now, you may find them disturbing. They're autopsy photographs, so the defense attorney, I've alerted to him to get him on and off the screen as quickly as possible to prove whatever he's trying to show you right now. But and then in the jury room, I'll make sure that they go inside an envelope so that you can choose to open the envelope or not when you're in that room to see them, okay? So they are admitted. What are they? What?
H.1-4.
H.1-4 is admitted hard copy.
Thank you. I'm going to show you H.1 from your autopsy. Is that a photograph, sir, of the 2 lacerations to the top of the head that you saw?
Yes, that's a laceration of 2 of the 4, or that's 2 of the 4 lacerations on his head.
Okay. And those didn't go below through the skull or anything?
They went through the full thickness of his scalp, essentially, pretty much down to bone. And 2 of them, the one on the left of that photograph, it had the indented small fracture underneath it. The other laceration was that had the skull fracture underneath it was not visible in that photograph.
H.2. What does that depict?
I believe that's a picture of one of his arms, and it shows obviously that most of the skin surface is absent, and sort of the exposed skin is often red, and then there are some of those linear abrasions, scratches, scrapes there on his arm.
3. What does 3 depict for us, sir?
Yeah, this is a photograph that's depicting the lacerations there on his left upper arm and the sort of abrasion with a smaller laceration there on the left side of his chest up there near his armpit.
And 4, sir, what does 4 show
This
us.
is a photograph of his back. Again, he's got diffuse burns, and then what you've highlighted there is the larger laceration that's on the back, his upper back, shoulder region.
Okay, thank you. So, as we went through all those injuries, in sum total, if you assume the van made those, and
It very well he may have. I don't know exactly what made every single injury, but the constellation of those injuries, lacerations on several parts of the bodies and skin scrapes, could certainly be due to being struck, especially if you went underneath the van and hit various objects that are on the undersurface of the van and on the ground.
Okay. I'm going to show you, before I publish it, I'm going to show you from Macioski's Exhibit 1E.1 to 3. Those again have been provided to counsel. They're your detective pictures.
Your Honor, and I mean this with all respect, I think the process is the issue here. Normally, when you admit exhibits, you admit hard copies for the witness and then publish to the jury. We just don't get them on an iPad. And the only concern being to ensure that these same exhibits that are being admitted here in court are the ones that are being provided to the jury. And I have no doubt Mr. Mueller would not do anything like that, but I just want to make sure that we're following the right procedure here with the admission of exhibits.
Your Honor, we have...
Going forward, I'll let you do what you will here, but going forward, I agree with Mr. Blair that it's a cleaner record if we, whatever it actually is that you're going to move to admit, if it's a hard copy, we do it as hard copy.
It will be admitted as a hard copy, but I could conditionally admit it with, to link it up under Rule 104 with Detective Macioski since they're his photos.
Well, I said I'll allow it this time, but going forward, further examination and exhibits, get us the hard copies, please.
Thank you. If I may have just approached the witness quick. Doctor, I'm going to show you about 3 photographs of the van that was involved in this incident. You see photos of the injury or the blood to the front bumper, or the what's called the brush guard.
Yeah, I can see some red material. I can't tell what it is, but could be blood. Yep, it looks like, again, similar material on the undercarriage.
Right.
Yep.
Okay. So we show Macioski picture 004, that's the van.
Your Honor, I don't think we've admitted these under a proper foundation yet. They're being published to a jury. They haven't been admitted. These are not his photos. I'm not even sure what foundation we've laid here.
Your Honor, under Rule 104, I can conditionally, I'll link it up and you can conditionally admit the exhibit because it's their detective exhibit.
Well, you shouldn't be showing it to the jury if it's not an admitted exhibit yet, so.
It can be conditionally admitted, subject to linking it up.
It hasn't been admitted, Your Honor.
In any event,
Mr. Mueller, let me rule on this. I'll have you wait and admit it when you can lay a proper foundation.
I'll be happy to do it with Detective Macioski. You've seen those photographs, sir?
I just now have, yes.
Those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it?
I mean, the injuries themselves, as I've stated before, very well it could be due to being struck and overrun and striking things on the undercarriage of a motor vehicle.
Right. So the fact of the matter is any of these blunt force trauma injuries that we had that we listed were not life-threatening. They didn't kill Todd Stermer, did they?
That was not my opinion, no.
Van impact, all those blunt force trauma did not cause death, correct?
Yes, that was my opinion. My opinion was that he died as a result of the burns and the inhalation of products of combustion during the fire.
Your Honor, I guess I'm not understanding why we're writing everything from the doctor's report on a tablet. My fear is that we already have the exhibit from the doctor's report. Now writing it can be misconstrued. It's not an exhibit. I'm not really sure why we're rewriting the doctor's conclusions or statements on a tablet.
Your Honor, I can examine and summarize his opinion. He agrees with this. This is simply presenting his opinion in a summary form as we're going.
Grant the prosecution's request on this one. The witness can testify and the jury can hear his testimony. It doesn't need to be written down by the counsel.
Okay. Then let's talk about, sir.
The tablet. Thank you.
Second thing, the burn injuries you talked about, you and I have talked before, right?
Yes.
And the burn injuries, you have told me, and you tell me if I'm summarizing this correctly, the burn injuries, you can't say, I know an accelerant was used based on these burn injuries, fair?
Yeah, that's out of my area of expertise to say exactly what type of burns they were. They're thermal burns. They may be flash or flame burns. I can't tell.
Okay. Third thing, let's talk about now the toxicology report. You discussed a little bit about the results of the urine test and the blood test, right?
Yes, I think we went through the toxicology results.
Okay, let me talk about that. I'm going to show you what we're marked, the toxicology report, which is part of the exhibit they showed you. And the urine specimen discussed hydrocodone, hydromorphone. Those are the metabolites, right?
Hydrocodone is a primary drug. Hydromorphone is a metabolite of hydrocodone that can also be administered as a drug on its own as well.
The blood test, let's talk about the effects of things in the blood test. See that?
Yes.
Yeah. The only thing it had was caffeine, correct?
That is correct. The blood screen was only positive for caffeine.
And when you have tests that have screens in the blood, that's what you have is basically the active ingredient, right?
Well, when it's present in the blood, we know that it's circulating and it's likely having effects on the body. If it's only in the urine and it's no longer circulating, then it may not be having its intended effects on the body.
Okay. It's if we talk about it, it's in your system versus out of your system. You've heard that before, right?
Yes.
He didn't have any of this hydrocodone or hydromorphone in his system, otherwise it would have been detected in the blood test, fair?
As I stated previously, there were no detectable levels. That doesn't mean, as I stated previously, that it wasn't possibly there at a lower concentration than what the testing screen is able to detect. So a negative result is essentially it's not there in a concentration that the test can detect.
And the test can detect concentrations that would have an effect on the body, can't it?
Generally, yes, that it's set low enough that if it is present below that level, it would be considered, essentially not significant.
Yeah. You also talked about Entex HC, right? Remember that this morning?
Yes.
That's cold medicine, prescription cold medicine.
I'm not familiar with exactly why it's used.
Okay. But it has hydrocodone in it, right?
Yes, it does.
And you said typically it's by a liquid syrup.
I believe, yes, it's usually given in a liquid form.
Okay. So any of this hydrocodone, as far as your professional opinion, would not have been in a system to have any effect on Todd Stermer. Fair?
Right. There was none detectable in his blood, so therefore likely he was not experiencing the effects of hydrocodone at the time of his death.
So if somebody, witness or the prosecutor, suggested that he had been drugged, that would be inconsistent with your objective evidence, wouldn't it?
It would be consistent with him being dosed hydrocodone sometime before he died.
In other words, therapeutic levels of hydrocodone, which would be just taking cough medicine, right?
There's no levels on there, so you can't say it's a therapeutic versus non-therapeutic.
I think he was testifying as to the time distance between the two, not whether it was therapeutic or not.
I guess I'm not clear on the question.
You've heard of the phrase therapeutic levels?
Yes.
All right, what does that mean to you?
They're generally levels that if you measure them are what you would expect to see or what's expected to be seen if the drug is in a concentration that is deemed to be effective from a clinical standpoint. So if you're talking about pain, what levels of medications cause or result in control of that pain. And that means in a sample, does the number that we're given for a certain drug fall within that range? Let's say the therapeutic range is 4 to 10. If a drug is present at a concentration of 6, then it would be considered to be within the therapeutic range and be in the range that is expected to exert its effect to treat whatever condition you're treating.
Bottom line, if he was taking cough syrup prescribed by his family doctor 2 days before, that cough syrup containing hydrocodone was out of his system by the time of this fire. Isn't
Your
that
Honor,
true?
he has no knowledge of what he took. If he wants to ask this as a hypothetical, that would be more proper than just testifying himself as to what the defendant did or did not do and then asking him to agree.
Your Honor, it is a hypothetical.
And there are no levels on the toxicology.
It is a hypothetical.
I'll ask you to rephrase it then, or state it again as a hypothetical.
Doctor, hypothetically, if Todd Stermer had taken cough medicine that was prescribed by his doctor 2 days before, Entex HC, for cold and ear infection, whatever effect that drug had was out of his system by the time of the fire.
Yes, in this hypothetical situation, if he took the drug 2 days before, it would be consistent with it not being detectable in his blood any longer, and he would not be experiencing the effects of that drug at the time of his death.
Or at any time before, because he didn't have it at detectable levels in his blood. Isn't that true?
Well, I'm not sure what you mean by at any time. I mean, if he had taken the drug 2 days before and 5 minutes later, he probably was experiencing the effects of the drug.
My question was poor. I'll try to rephrase it. Mm-hmm. If at the time of the fire he didn't have this hydrocodone in his system, you with me?
Yep.
Then no matter when he took it, whenever, it was out of his system.
Right, I think it's fair to say that, given the apparent brief time period between the fire and his death, that his concentration of those drugs would have been similar to what we see when he died, and probably was not under the effects of the drugs at that time.
Just going back to the idea of these lacerations on a blunt force trauma, you had 4 lacerations in 4 different places, right?
Are we speaking of just the head?
Yes.
Yes, there were four separate lacerations on his head.
So if there was a suggestion that maybe Todd Stermer got hit by a frying pan, that wouldn't be consistent with the injuries you saw, given that he had contact with the undercarriage of the vehicle. Isn't that true?
Well, again, that's, I guess, a multi part question. To answer your first question, I can't rule out that he wasn't struck with something based on just the lacerations. He wasn't struck one time with something, but clearly there are impacts to his head, and I can't tell you exactly what caused those impacts. Given the fact that it was reported to me that he was run over by a vehicle and there was evidence of body fluid on the undercarriage of the vehicle, it seems quite reasonable that that would be an explanation for the injuries that were seen on his head.
As you like to say, within a reasonable degree of medical certainty, it's more likely than not that all of those injuries to his head...
Objection, Your Honor, that's not what he said. It's mischaracterizing the evidence.
She can clean it up if she'd like.
No, I think I'll sustain that objection.
Your opinion is it's more likely than not, given the evidence you...
Same question, Your Honor. Objection for the same grounds.
I'll sustain the objection. I don't think he's given that as his opinion.
Do you have an opinion, whether it's more consistent, given the data you have, that he suffered those head lacerations from impact with the undercarriage of the vehicle?
I mean, I think I've answered the question that I don't know exactly what caused each of the lacerations. They are explainable by injuries sustained from the undercarriage of the vehicle. Can I exclude that there wasn't an injury from something else prior or in association with it? There's nothing specific about them that allows me to say definitively what caused them.
Based on the evidence you encountered and addressed in 2007, right?
My opinion is that based on my interpretation of the injuries, they are caused by blunt impact. They could be from the undercarriage of the vehicle, and they very well may be, but I can't say definitively what caused each separate injury.
Okay. Now, part of your process when you're doing forensic examinations, you're familiar with the scientific method?
Yes.
Scientific method is you collect all the data you can relevant to your topic, right?
Yes, as part of what I do, I collect data.
Okay, now listen to me and we'll see if we can work through this step by step. You collect data, right?
Yes, we've established that.
As much data as you can that might be relevant.
Yep.
Then you analyze that data, right?
I interpret the data.
Then you develop hypotheses, which are really just working theories of what it could be.
I mean, that's the scientific data. I do an examination, I interpret it based on my training and my experience, and come up with what I believe is the most accurate conclusion.
Okay. You test your theory against the evidence that you have, right?
Well, in my line of work, I try not to come up with a theory and then make the data fit my theories. I take the data and I interpret it based on my knowledge of pathology, forensic pathology, and the circumstances in which the death has occurred.
Okay. You understand the scientific method is to develop, when you test your theory, to try to disprove your theory, to rule out something.
Yeah, I understand that the scientific theory. I'm telling you what my protocol is in determining cause and manner of death.
And your protocol in determining cause and manner of death involves what you folks call in the medical field differential diagnosis, right?
Well, yeah, a differential diagnosis is when you take a finding and you come up with a list of possibilities that may explain that finding. For example, I don't treat patients, but if you come to the hospital with abdominal pain, they will take a history and they will say, well, we think your abdominal pain may be due to this, this series of potential diagnoses, and we will do further analysis to try to shorten that differential diagnosis, hopefully to a definitive diagnosis.
Right. So you're taking, it might be 3 or 4 things, and you're taking tests to try to rule out something, and ultimately you have a diagnosis. But you have to consider what it could be, right?
Right. I mean, when I look at an injury on the body, I have to evaluate an injury independently and determine whether it's a blunt force injury like a laceration or a stab wound or a gunshot wound or something else. That's part of what I do in not just saying there's an injury here, but then analyzing the injury based on my experience and my training to determine what that injury actually is.
Like a simple one. If this was suggested that Todd Stermer died of a gunshot wound, your examination of the body finds no gunshot wounds, right?
That is correct.
So you could rule out gunshot wound, correct?
That is correct.
That is part of how you do the differential diagnosis. And now we'll forget gunshot wound, we'll focus on something else, right?
Right.
Okay. So, in terms of his thermal injuries, these burns to the skin obviously would be painful, right?
Yes, I've never experienced burns like that, but I have burned myself and it hurts.
It hurts. And the pain is immediate, isn't it?
Yes.
Now let's talk about your manner of death and what you've considered. Am I right that when you're talking about manner of death, there are several different categories?
Yes, there are 5 categories in the state of Michigan that you can put on a death certificate for manner of death.
Would one be accidental?
Yes.
Would one be suicide?
Yes.
Would one be natural? You had a heart attack?
Yes.
Would one be homicide?
Yes.
And one would be undetermined?
Yes.
And if it's undetermined, the only one that supports a crime is homicide, correct?
I'm not sure that that is a correct statement. For death certification purposes, it's not for use in this setting. When I put something on a death certificate, it is for death certification purposes, for public health, for statistical purposes. For example, most automobile crashes we classify on the death certificate as accident. There's no intent generally to cause harm, and yet I've sat on a stand like this multiple times on cases where I've called a death an accident, but someone has been charged with a crime, say driving under the influence or reckless driving. So just because I call something an accident, or it's not legally binding in the sense of the judicial process. Likewise, just because I call something a homicide doesn't necessarily mean that from a legal sense a crime has been committed.
Sir?
Yes. I'm trying to answer your question, which is only one of them indicates a criminal activity.
Can you answer my question, yes or no, if you're able to?
Restate the question.
That's badgering the witness. He asked for an answer. The doctor gave him an answer. It was directly in response to his question.
She can
He
follow.
is badgering the witness.
That's hardly badgering the
I'll
witness.
sustain the objection.
Sir, you make these categorical classifications based on the evidence you have at the time, am I right?
Yes, based on the autopsy findings and the circumstances in which the death occurred, I provide an opinion as to what I believe is the manner of death.
Okay. And in this case, your manner of death was undetermined, isn't that fair?
That is correct. That's what is stated on my report.
If you had evidence at that time that it was a homicide, you would have listed it as a homicide, correct?
If I had had enough evidence that I felt independently comfortable that his death was due directly to someone else's intentional actions, then yes, I would have called it a homicide.
Okay. So let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries, fair?
Yes, I believe his death was caused by the thermal injuries.
You're not qualified, and you can't say that an accelerant, gasoline or anything else, had a connection to his burn injuries, fair?
Right. I don't do accelerant testing. That's out of the realm of what I do.
There were no drugs that were detected that were in his system at the time of his death, fair?
That is correct.
And finally, the manner of death is undetermined, fair?
That was my opinion at the time, yes.
Give me 1 second, Your Honor. I know you're a busy man, Doctor. I don't have any other questions for you. Thanks.
Yep.
Thank you, Your Honor. Doctor, you don't need to know anything about the specifics of the van to do your report or your examination, do you?
No, not to actually do the autopsy. I mean, when asked questions to try to correlate injuries, then yes, it's sometimes useful to know, but to determine that those are blunt force injuries, I don't need to know any specifics about a vehicle.
It was enough information to know it was a van.
Yes.
And I just want to be clear on your findings. Those rib fractures could be from CPR, correct?
Definitely the two left-sided anterior rib fractures very well it could be from CPR. As I've stated before, the posterior rib fracture would be unlikely to be due to CPR.
But even the other ones could not be from CPR.
That is correct too. I can't tell you that the ones on the left side in the front, I mean, they could be from something else. They're just, they could be explained by CPR.
Or they could be explained possibly by the van.
Yep.
And the injuries, the 4 separate lacerations on the head could be from the van.
Yes.
They could be from another blunt force trauma.
Right. If he had been struck with something else prior to being run over, then one or more of them could be from being struck. I can't say with absolute certainty that.
They could be from a frying pan.
Potentially.
It would be consistent with the injury, right?
Yeah, there's nothing specific about the injury that would allow me to say that he was or wasn't struck with something.
And I just want to be clear, you did the autopsy on January 8th. The fire was January 7th, so you're talking one day after, correct?
Yes.
And so you based your information and your report on the information you had the day after the fire?
Well, I mean, the final report wasn't issued until at some point later, so there probably was some more information that was obtained. But everything that all the information is summarized in my report as to what I had at the time that the report was issued.
And that's what you used then to come to your conclusions?
Yes.
And I just want to touch base, you talked about the pain that would be, that somebody would have from those burns. Would touching then also cause additional pain to the patient that's burned that badly?
I would assume so. I'm not an expert on pain, but it would be painful.
Greg asked him to speculate. He's not qualified.
He's a medical doctor.
Now he's talking about I would assume.
So based on you saying that it would be painful for somebody to touch those burn injuries?
I would assume that the burns just of themselves would be painful. And I assume that touching them or moving him would have also been painful as well.
How about laying on him?
Again,
Same objection, lack of foundation. He doesn't know what the situation was.
Outside of his area of expertise at this point, so I'll sustain.
Okay.
One hand goes beyond my cross.
The rules of evidence allow that, but I'll sustain the objection.
I have no further questions, Your Honor. Thank you.
As a medical professional, you deal in probabilities, not possibilities, don't you?
Well, I mean, my diagnoses are usually made on some degree of probability. Many, many things are possible. I try to deal in what is most probable.
Because if you're dealing in possibilities, you're merely speculating, aren't you?
I mean, I guess to some extent, if it's possible, then I can't exclude it.
But it's guesswork to represent that it was something affirmatively to a jury, correct?
I mean, I don't think I've stated anything that I don't think is probable.
Not accusing you, doctor, but because you deal in probabilities, to say it's possible it could be something and have a representation that it is that would be misleading, wouldn't it?
But I would never say that something is definitively this just because it's possible that it's that.
Okay. Have you had any autopsies where somebody was struck by a frying pan?
I don't recall.
Okay. If you get struck by a frying pan, typically it's right.
I don't know, I've never been struck by a
I
frying
object, Your
pan.
Honor. He's dealing with autopsies. He's certainly not there when somebody gets struck with a pan and how it affects them.
You can talk about the injuries. And
That was beyond the scope
Sustaining
of
an
injury, Your
objection,
Honor.
this is outside of his area.
it would typically result in a skull fracture, wouldn't it?
Probably that's an overstatement. It could result in a skull fracture.
Okay. Or not.
Or not.
Thank you. No more questions.
I have no further questions, Your Honor.
Jerry, do you have questions of him? Oh, yes. Oh, my gosh. Need more? Okay. have some questions from the jury. Do you know the performing laboratories' cutoff levels for their test validation or their established levels of detection and level of, some of you have really bad handwriting, level of quantification for their drugs?
So the testing that was done at the time was done at a laboratory that no longer does the testing. I don't know any of the specific parameters for like the level of detection for any of the substances that they tested, nor any of the particulars regarding that. Having done this for a long time, they're generally relatively low, so I would expect that had there been something there in significant quantities, it would have been detected. But no, I can't give you, like for hydrocodone, their level of detection was 0.5 nanogram per milliliter. I don't know those parameters.
Similar question. Do all labs use, if you know, do all labs use the same detection levels for blood and urine?
No, they do not. Typically, the detection levels are quite different for blood and urine specimens. Urine specimens usually are significantly higher concentrations, the lower concentrations, just because the drug tends to accumulate in the urine. So they generally have higher detection levels in urine. Most labs don't quantitate or give you a level in the urine, but they generally will, at least in the forensic setting, in the blood. And those detection levels may vary from laboratory to laboratory.
You stated that 90% of the body was severely burned with skin intact at feet and part of a leg. I'm curious how a fingerprint can be taken when skin is burned off or sloughed off. Please further explain.
Yeah, he had burns to his hands. The skin actually was mostly sloughing off of the hands. So with burns, a lot of times the outer layers of the skin separate from the inner layers. And in this case, it wasn't present. You couldn't see it in the photographs, but there was still skin on the fingers. It basically was just sort of sloughed off, like if you were wearing a latex glove and you pulled it off. It was still there, but it really wasn't in place where it normally should be any longer on the hand. So in many cases, we are still able to get fingerprints in bodies that are burned, as long as the hands themselves aren't completely, the skin isn't completely burned off. In this case, the skin was more sloughed off of the hands than burned.
Okay. And there was one question, jury, that I'm not going to be asking. I've determined under the law not to ask it. Could lacerations be sustained from a fall or from a fall on stairs?
In this specific case or in general?
My guess is, how about both?
Okay. In general, yes, lacerations can occur anytime there's an impact. So if you fall downstairs and you strike your head on the wall, on a railing, on the floor, yes, you could get lacerations. I think, as I've stated before, I can't tell exactly what caused these lacerations. So, could one of the lacerations or more of the lacerations be from falling downstairs? I couldn't exclude that.
Thank you. If blunt injuries were possibly caused by the van, would the amount of blood on the van be there as soon as the body was impacted, in your professional opinion?
Typically, blood is transferred at the time of an injury. So, if you're struck by something and it causes a laceration of the skin, that generally you're going to bleed, and there will probably be blood on the impacting surface. So if you fall and hit your head on the corner of a table, there's likely going to be blood on the corner of the table. There may be a lot more on the ground after you fall and bleed, but yes, there would likely be blood on an impacting surface.
Thank you. Is there any testing of the surface of the skin to determine if there is anything, in parentheses, substance, on the skin? And also, did you receive any documentation in regards to Todd Stermer's pants or lack of pants?
I guess the question is like what sort of substance. Our laboratory testing of the body is usually body fluids, and they're usually being analyzed for medications, drugs, that sort of stuff. I can't test like the body surface, for example, for an accelerant. That's out of sort of my area of purview, if you will, when doing an autopsy. And what was the second part? Sorry.
Oh, it had to do with Todd Stermer. Here we go. Did you receive any documentation in regards to Todd Stermer's pants or lack of?
Not that I recall.
Okay. Counsel, any questions in light of those questions and answers?
No, Your Honor.
Mr. Mueller?
Yes, just a few. There was a question about if you fell down the stairs, could you get these lacerations? You had 4 different lacerations in 4 different spots on the head. You with me?
Yes.
That wouldn't be consistent with a fall down the stairs as compared to being under the undercarriage of a van, as you saw those pictures with the blood.
Well, again, you know, it all depends. I mean, if you fall down the stairs and, you know, you fall down 20 stairs and you hit stair number 4 on one side of your head and you hit stair number 12 on the top of your head as you're tumbling down, you may have more than one impact site. What we're talking about are, you know, lacerations that are very distinct from each other, are indicating, you know, different impacts. So anything in which you could potentially sustain multiple impacts could result in you having 4 lacerations on your head, whether that being falling down multiple stairs or being hit multiple times in the head with something, or being run over by a vehicle and hitting multiple parts of the undercarriage of a vehicle. There's nothing about them specifically that allows me to say I know what specifically caused them.
Okay. Something along the lines of 20 stairs, you said?
I have no idea. I'm just saying that you would have to have 4 impacts with something, either the stairs, the wall, something.
Again, that's a possibility, correct?
Yes, just like the other scenarios I gave are possibilities.
Thank you.
Also a possibility, it could have been a combination of all of those things, is that correct?
Right, I can't say that they're not from more than one event or more than one object.
No further questions.
Jury, any more questions? Okay, we've got one more, it looks like. Question, but we'll try it again. Is it possible for a drug to be present but below the level of detection?
Yes, as I stated before, a negative result just means that the drug is below the level of detection. So if it's not there at all, then it would be negative and it wouldn't be reported. If it's at such a low concentration that it doesn't reach the minimum level of detection, then it would also be reported as negative in that instance.
Any questions from you two?
I do. Let me get this right. If it's below the level of detection, and you said they're low thresholds, right, for the blood?
Generally, yes.
Okay. Below the level of detection, it could be 0, there's nothing in there, right?
That is correct. It could mean that the drug just isn't there.
Or it could just simply be below that low threshold, that sensitive threshold to detect, fair?
That is correct.
Either way, in this case, it was not in his system, correct?
There was nothing detectable other than caffeine in his system.
Thank you. I wouldn't want anybody to detect my caffeine level.
No, Your Honor, I have no questions.
Going once, going
Have a distinctive odor, and how would you describe it?
At the time I do the autopsy, it doesn't generally have much of an odor in most instances. In bodies that are severely burned, I mean like charred to the point where they look not even like human bodies anymore, then they do have a smell, and it smells, unfortunately, like something most of you have probably experienced, which is, you know, burnt flesh from animals, what we would call meat. So unfortunately, you know, fortunately he wasn't burned to that extent, but in more severe cases it does have a, you know, a smell of essentially burning meat or burning flesh.
Counsel, any questions in light of that? Ms. Ivan?
I just would ask, would your body fluids have more of a smell as you're burning? You talked about how the outer layer skin's coming off and the fluids are seeping out.
I mean, at autopsy, unless they're severely burned and charred, I don't usually notice like a distinctive smell just from a body that was burned, like in this case.
So by the time you get the body, you wouldn't even have any detection, even on a less severe burn?
Like I stated, on a severely burned, charred body, when we open the body bag, they generally smell like, you know, you've burnt something on your grill. If they're not to that point, then typically I've not recognized a distinctive odor.
Thank you. I have no further questions.
No questions.
Any other questions, jury? Yep. Okay, go ahead. Question?
Sorry.
That's okay. Yes, there is. Question from the jury, no objection from counsel. Can loss of blood contribute to detectable levels?
Generally not. As long as we have enough blood to submit, since it's a concentration and amount per the amount of blood that you have, it doesn't generally affect our ability to detect drugs. So, a normal human body probably has, a few liters of blood. What we submit for testing is generally, a few milliliters, and what they actually test is oftentimes even a smaller amount than that. So generally, the drug is fairly uniformly distributed throughout your blood, and what I get is a concentration. So whether they analyze 4 milliliters of blood or 1 milliliter of blood, it should give the same relative concentration.
Any follow-up, counsel?
No, Your Honor.
None, Your Honor.
Any other questions, jury? No? May he be excused from his subpoena, counsel?
I would ask that you please be excused, Your Honor.
Thank you, Doctor.
Thank you, sir. Oh, wait, one more question. If you could hand me the exhibits, and I'll take care of this. Is that yours? Okay, thank you. Siderman, did you want to take a break now, or?
That sounds great, Your Honor.
Okay, so jury, we'll take a 15-minute break before the next witness. Remember the rules. You can leave your binders in the chairs. We're back on the record. People versus Linda Stermer. Jury's not here. Anything to address before we bring them in?
No, Your Honor.
I just have one point to make. They're going to be reading from Mr. Shinsky's interview with Linda Stermer from January 9 and 10. This document says it's a draft. So unless he can testify how accurate it is, who did it, I don't know. And they want to admit this as an exhibit in total. So
I don't know what you're talking about. Is this the next witness you're referring to?
it's a transcript of her interview. It's one of the things I indicated. Not only do we have hearsay, not only do we have relevance objections as to the whole transcript,
Right.
but it's a draft. Who knows who did it?
Is that coming up next?
No, Amy Darling's
Oh,
coming up next.
no,
and Shinsky will be
she'll be
following
short,
that.
and he'll be right after that.
Yes.
What is this, a transcript that's being read by someone?
Well, I have a transcript that was taken by Linda Shinsky as part of the fire investigation. It's all recorded, and so what he did is then he had it transcribed and then checked the transcript for accuracy against the recorded interview. So at the first trial, it was admitted in its entirety as an exhibit, the whole transcript of her interview, and we were intending to do the same.
So you're familiar with it? Here's what it is. Here's what it looks like.
The draft?
Yeah.
So there's a concern about it being called draft?
It's a draft, and we don't know who did it and how accurate
Ours
it is.
doesn't
It's certainly not a
say
court
draft.
reporter.
Ours doesn't say draft, it's the original exhibit from the trial.
You have the original?
This one here was marked as exhibit number 13 on January 6, 2010.
Well, I
With the sticker.
have one here that doesn't say draft, and he'll testify as to the accuracy.
Okay. So do you want her to provide you the one that doesn't say draft?
Yes.
Okay. I guess my staff can make copies to keep things moving.
Here, I've got it. I've got, you want to email it to you, or?
Have somebody run a copy and give it to me by the end of the day.
Yeah, I have an electronic copy on a flash drive I can send right now.
Okay.
If he wants a photo digital copy, a hard copy, I can have some print off downstairs.
Mr. Mueller, did you want, I heard you say end of the day, but I couldn't hear what you said otherwise.
I want a hard copy today.
By the end of the day.
Can you just give us a few minutes, we'll hand it to him.
Okay. Anything else on that matter before I bring in the jury?
No, Your Honor.
Okay. Bring in the jury. Ms. Idevine, you may call your next witness.
Thank you, Your Honor. Please call Amy Darling to the stand, please.
And before you have a seat, I'll have you pause and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you. Please have a seat. And when you're settled, we'll have you give us your full name and spell the last, please.
My name is Amy Elizabeth Darling, D-A-R-L-I-N-G.
If you can move that microphone up a little bit closer so the jury can hear you. Thank you. Ms. Idevine?
Thank you, Your Honor. Ms. Darling, what is your current occupation?
My current occupation is Drug Command Program Manager.
And how long have you been in that position?
I have been almost 3.5 years.
And what did you do prior?
Prior to that, I was a 911 dispatcher for Michigan State Police.
How long did you do that?
Almost 18 years.
18 years. And at any point were you then also the medical examiner?
I was.
What years were you the medical examiner?
From 2000 until 2000, my apologies, 2022.
So you do that in conjunction with your other
I did.
occupations? And can you explain to the jury what a medical examiner is?
Medical examiner investigator is a person who goes out and any unattended death in the county that I resided in, which was Van Buren County, is investigated. Findings are then taken to a medical examiner or to their primary doctor to determine cause of death.
So you assist on scene, is that correct?
Yes, ma'am.
And you're called out on all deaths?
Any unattended death, correct.
What's unattended death mean?
Unattended death is any unwitnessed death by physician.
So for example, if a physician has somebody with a heart attack in the hospital, you don't have to go there?
Correct.
This would be just anything out in the community that a law enforcement person would call you and say that a doctor didn't witness this.
Law enforcement, emergency services, for ambulance services, first responders.
Okay, perfect. And as part of your position as a medical examiner investigator, were you called out to the scene on January 7th of 2007 to the Todd Stermer home?
I was.
Do you recall approximately what time of day you went out there?
Approximately 16:30.
So 16:30 in military time
My
is...
apologies, it's 4:30 p.m.
4:30 p.m. Perfect. And can you, so do you remember what you did when you first arrived?
I did.
And what did you do?
I went up, I made contact with the law enforcement that was on scene and the EMS personnel that was still on scene with the decedent.
And did you drive down the driveway?
That I do not recall.
So once you got to the residence, you made contact with who?
The law enforcement and the ambulance personnel that was on scene.
And do you recall approximately how many people were on scene at that time?
No, ma'am, I do not.
Was it chaotic or were a small number of people?
It was pretty chaotic. Law enforcement was there, fire department was still there, emergency medical services were still on scene.
So all of the ambulance, fire department, police, everybody was still there?
Yes, ma'am.
Okay. And what did you do then when you arrived?
I took custody of the body from the ambulance personnel and received reports from them about their attempts to resuscitate Mr. Stermer.
So you spent time talking to people on scene about the attempts?
Correct.
And what attempts were you aware of at that time?
The ambulance scene performed advanced cardiac life support, which involved trying to establish an airway, trying to restart his heart, both by electric mechanisms and by performing cardiopulmonary resuscitation.
So once you were advised then of all these attempts, then what was your next action?
My next action was to examine the body.
And where was the body?
I'm sorry?
What, the body?
Examine the body.
And where was the body when you had the opportunity to examine it?
The body was out on the ground, away from the house a little ways.
So still on location on the ground?
On location on the ground.
And what did you observe when you examined the body?
First observation, it was that there was a figure underneath blankets. Blankets were removed to find a couple jackets that were laid over the decedent. Those were removed. Find a white male that is sustained burns all over his body to the point where his skin was sloughing off and his fingers were degloving. There were signs of medical resuscitation efforts, including defibrillator patches. There were burn singe marks all over his body that were still contained skin slippage, which means that the skin was falling off of the body itself. The male had burnt, singed skin up around his face. His hair was down to stubs both around the facial area and throughout his head. where normal hair growth would have been. It was unknown if that was his haircut or if it was from the burning. The decedent also had dirt that was on his knees and shins that was caked into the grooves in his knees. He was found to have a laceration on the back of his head that was open and substantial burns on the left shoulder with an open laceration on his bicep area.
Was there any bleeding at that time?
Yes, ma'am. It was prevalent of the seepage. It's not necessarily bleeding when they're deceased at that time.
So, okay, so you had seen the seepage. Was there blood present on the scene with the body?
The body had been moved prior to my arrival. The first responders, after I did my examination and readied the body for transport and secured it, talked to the investigators that were first on the scene and our resuscitation efforts. They actually moved the body away from the burning structure prior and relocated it. So there was no pooling of blood or bodily fluids at the location where the decedent was found.
And at that time that you arrived, was there any heartbeat?
No, ma'am.
Any pulse?
No, ma'am.
And did you pronounce him dead on that scene?
I did not. The paramedics that were on scene called Lakeview Hospital, and they established the time of death as 16:17.
And once that time of death was established, what's your role?
My protocol is that I'm called out after that is determined.
I apologize. So that actually happens first?
Yes, ma'am.
And so after you've had the opportunity then to examine the body, what's the next steps that you take?
Then I talk to the personnel on scene, trying to get as much information about how the body came to be in its location, information about it, who the responders were on scene that I could ascertain. Then the body is then secured in a body bag, and at this time the medical examiner had determined that it definitely needed to go for an autopsy. So the body bag was secured in that fashion. The zippers were tied, and it was sent with Calvin Funeral Home to Sparrow for autopsy.
So you say that the body bag was secured and tied. Can you explain to the jury what that means?
Secured and tied means instead of placing a security device on one zipper where it would contain the name and possibly, if we had at the time, the case number for the decedent, the zippers are actually put together and tied together. And then the decedent's identification information is added onto that.
Does that have to be clipped with a tool then to be able to be opened?
It has to be clipped in order to move the zippers.
So not something that somebody could readily just open?
Correct.
And there'd be evidence then if somebody were to break into that?
Correct, because the name tag would not stay attached to that zipper that way, the way that it's secured.
Did you also take photos then of the body?
I did not.
You did not. Do you know who did?
I believe the sheriff's department, but I'm not for sure.
Were you present when they were taking the photos?
No, ma'am, I was not.
Okay. And you mentioned that there were several articles of like clothing laid on the decedent?
Yes, ma'am.
And what is done with those items?
So the articles that were covering the decedent's most of his body, the jackets and blankets were set aside. The decedent had socks, underwear, and sweatpants that were on. The underwear and sweatpants were collected by the fire marshal who was on scene because they had the odor of accelerants on them.
And then what happened with the other items?
The other items are left there for the police officers to either take with or they're discarded.
Do you recall what items then went in the body bag then with the body?
The pair of socks is the only article of clothing that went with them.
Was there any of the items that were thrown on the body that would have gone in that body bag?
Not to my knowledge.
Okay. If somebody were to have put one of those items in, a shirt, would you have known about it?
I would have seen it.
And you did not see a shirt?
I did not recall seeing a shirt.
Okay. And you said that a few of the items then were taken and released to then who?
The fire marshal.
The fire marshal.
Michigan State Police Fire Marshal.
And do you know who that was?
That was Sergeant Leroy.
And then did you do anything else on scene?
No, ma'am.
So once the body's taken away, then did you just leave?
Correct.
Okay. I have no further questions, Your Honor. Thank you.
Doctor, I'll start out with a simple question. You don't know what caused the fire in this case, correct?
No, and I'm not a doctor, sir.
I thought you said you were...
A medical examiner investigator.
My fault.
Nope,
Sorry.
that's okay.
Okay. You don't know what caused the fire or where it started, correct?
Correct.
Okay. Let me back up a little bit. When you come out, do you have a notepad or a binder where you're checking off stuff? How do you keep track of what's on a body at a crime scene?
What's on a body at a crime scene?
Like we had clothes here, you're responsible for making sure things get to the medical examiner's office for an autopsy, right?
Correct.
Okay. How do you document what's on there so you know?
I write a report.
And you wrote a report in this case?
I did.
In this particular case, you said Sergeant Leroy took the sweatpants and the underwear from the scene, correct?
He took them from the decedent as evidence.
Did you see him do that?
Yes, I did.
Did you, obviously you authorized him to do that?
That is part of the investigation, correct.
What if that's considered evidence? It might be a possible crime, right? You understand that?
Correct.
Right. Why is Sergeant Leroy taking evidence from a possible crime scene without the body first going to the medical examiner's office to determine what relevance it might have?
Sir, that would be something for the fire marshal. I don't know their protocol. It's between them and the detective bureau.
Okay. Am I clear? And you worked for Van Buren County?
I worked for Van Buren County Medical Examiner's Office.
Okay. At that time?
Correct.
Did the Van Buren County Medical Examiner's Office have any kind of a policy, written policy regarding allowing evidence, clothing, whatnot, to go from a crime scene without being okayed, or strike that, without being transferred to the medical examiner's office who's going to do the autopsy?
When it is deemed that it's part of the protocol that if it is law enforcement and they are taking it as evidence, not just take it and discard it, they are in charge of that.
Okay. That is a written policy by the Van Buren County Medical Examiner's Office?
Sir, I don't have access to that. I couldn't give you the exact, that is how it was functioning.
Okay. That was the custom, is what you're telling us.
Sir, I cannot say for sure if it is in a written policy.
Okay. Or a formal procedure, it's just that's the way it was done?
That was the way it was done.
Okay. In this particular case, you need to make sure there is a chain of custody, am I right?
Correct.
So you document in your report what was taken with the body bag and to the medical examiner's office?
Correct.
Did you say there was a funeral home? It goes to the funeral home first?
It's transported by a funeral home. I don't have the ability to transfer a body in my personal car.
Okay. So a funeral home gets contacted, hearse or something?
Correct.
All right, then they take it to the medical examiner's office for an autopsy.
Correct.
Anything else that you remember that Sergeant Leroy took?
No, sir.
How many, this is 18 years ago, how many scenes have you been to in the course of your career?
Sir, I couldn't tell you.
Countless, right? And yet you remember the odor of an accelerant on this particular body 18 years ago. Is that right?
Correct.
And in your report, you must have, that would have been important, right? Mm-hmm. Yes?
Correct.
Did you write that down in your report?
I did, sir.
Can I see that? Do you have it in front of you?
Would you like me to show you where, sir? so you don't have to search around.
I'll take it, thank you. And once the fire marshal was present, you were letting him take over in terms of whatever, and this would be Sergeant Leroy, thought was relevant. Fair?
Negative, sir.
Okay.
I'm in charge of preserving evidence on the body. If he had something that was on the body, or one of the detective bureau had something on the body that was deemed as evidence, they could secure that. They weren't allowed to take a sampling of vitreous humor, the fluid from the eye, or blood, or anything that pertains to changing the composition of the body.
Of the body itself?
Correct.
Okay, so in your report, one of the things you learned, you tried to get the background of what was going on, right?
Correct.
And you learned that Todd Stermer, where you found him, wasn't where he originally was when the first people who came on the scene got there, right?
Correct. That's in my report.
And in your report you said, after they moved him, they found him in cardiac arrest. They removed him from the boat and started CPR. So you learned at some point in time that there was a boat involved. Is that correct?
Correct.
Okay. Nobody told you a little 3-foot sled or anything, right?
Negative, sir.
Let me give this back to you. Was the end of your involvement when the body was transported?
Correct.
So you only had a short period of involvement, is that right?
Correct.
Okay. You took no photos, correct? You did write that report, right?
Correct.
Okay. Would you agree with me that chain of custody is very important in your business?
It is.
Why?
Because it is a legally defensible chain of evidence.
And that's why you have procedures.
Correct.
To protect that chain of custody.
Correct.
Including the underwear in this case.
Correct.
Okay.
I wouldn't have handed it off to a firefighter. I handed it off to a law enforcement official.
Okay. Are you aware, and you're certain about your memory, right? You seem to have a good memory about it, even though it's 18 years ago. Yes?
Correct.
Are you aware that Dr. Markey testified that the underwear and socks were in the body bag?
I was not. I'm going off of what I had documented down.
Okay. If Dr. Markey testified to that, you may possibly be incorrect. Isn't that right?
Correct. I'm going off of my report. As you said, it was 18 years ago.
Working for the county medical examiner's office, you have testified countless times on the side of the prosecution in cases just like this, right?
No.
Have you testified ever in a case like this for the prosecution?
I have testified one prior time.
In your whole career?
Correct.
Okay. And that was for whom?
That for Van Buren County.
For the prosecutor's office?
Correct.
And before you came here today to prepare for today's testimony, I imagine you met with the prosecutors?
For about 5 minutes on recess.
Okay.
While she was filling her water.
Give me 1 second, Your Honor. You were an investigator. You were not the head of the medical examiner's office, am I right?
Correct.
Okay. So when you get to the scene, you're talking to the law enforcement people just to get your arms around what happened.
Correct.
And that's how you got that background about the boat.
Correct.
Okay. Who determines what evidence is going to be taken with you or under your, I'm going to say jurisdiction, versus a fire marshal deciding what he thinks he needs?
That's dependent on the situation.
Let me just drop some. Would it typically be if a law enforcement officer thought that there might be a crime, he or she has the discretion to take what they want?
I do not have training in law enforcement. I don't have any say as to what I can or cannot do to assist or impede in their investigation. Mine is the body.
Yours is the body, but you agree with me that evidence on the body, including clothing, maybe jewelry or whatever, could be important evidence, fair?
Correct.
Right. But you don't have that discretion to tell the law enforcement person this goes to the autopsy?
We could discuss it, but that was not my call. My expertise is not fire marshal. I have no idea or reasoning behind why he would need those clothing or tell him how to do his job.
Okay. And you are not aware if there is in fact a written policy regarding authority to take evidence off a body?
Your Honor, that's been asked and answered.
Just real quick, you were doing this for 13 years.
Correct.
All right. You've done countless scene examinations just like this, right?
Not just like this, no.
Where you come out to a scene and examine a body.
Yes, sir.
Okay. And you're not aware of what the policy is.
Your Honor, asked and
That's not asked and answered. You know, you get to one last question. And you're not aware of the policy, fair?
I do not have a written policy that was in place.
Well, there was no written policy.
I do not have it. I do not have what they have. I've not been in this field in many years.
Okay. But you had it back then.
The standard of practice was to let law enforcement do their investigation. Mine was the investigation for the body and the reporting to the medical examiner.
Thank you.
You're welcome.
Thank you, Your Honor. So I want to just kind of talk to you a little bit about that chain of custody. So when you seal that body bag and you secure the zippers with the tag, and it goes to then the autopsy, it's secured, correct?
Correct.
So if Dr. Markey, who did the autopsy, opens up the body bag and documents what's in the body bag, do you have any reason to doubt that that's incorrect?
No, I do not.
And so that would be documented in the pathology report to the best of your knowledge, correct?
Correct.
Okay, no further questions, Your Honor.
No reason to disagree if Dr. Markey said the underwear was in the body bag contrary to your report.
Sir, I can only attest to what I have as documentation.
Okay. Question is, you have no reason to disagree with it, I think you said.
If Dr. Markey has that documented, that's what shows in his documentation.
Thank you.
No further questions, Your Honor.
Jury, any questions of her? No? Thank you, ma'am. Is she excused from her subpoena?
I would ask that she please be excused from her subpoena, Your Honor.
Thank you. Thank you, you're all done.
To the stand, please. Yes, I do. Thank you very much.
Good afternoon, sir. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. The chair is pretty clunky.
A little more leg to fit in
Okay.
there.
And then you can move the microphone towards your mouth and let us know your full name. Spell the last, please.
Name is James Shinsky. The last name spelling S-H-I-N-S-K-Y.
Thank you. Ms. Ivey?
Thank you, Your Honor. Mr. Shinsky, what is your current occupation?
I am technically retired from the Raymond Corporate Investigative Services as a fire investigator. However, I'm still on their part-time payroll as needed to finish the cases that I left behind.
And how long have you been in that role?
A fire investigator.
Fire investigator.
I started my training and investigation on my first fire as a trooper in 1982.
And then when did you start then? So you were a trooper for how many years?
I retired from the state police in 2003. I was a full-time fire investigator for 8.5 years, 6.5 years running the training and certification in schools that the state police puts on for other agencies. Retired in August of June of 03, and then went to work for the Raymond Group in August of 03, and I'm still there.
And what did you do then with the Raymond Group?
Full-time fire investigator.
Okay. And so who would hire you as a fire investigator?
Law insurance companies, law firms. Sometimes we'll get, corporate jobs, product liability stuff. They need a fire investigator.
And as a role as a fire investigator, did you become involved in a fire at the Stermer residence in January 7th of 2007?
Yes.
And what was then your role with that particular fire?
Determine the origin and cause of the fire.
And were you then to interview, did you conduct interviews?
Initial preliminary interviews, general information about the site, the events of the day, do the origin and cause investigation, and at that point, depending on your findings, would be the end of my role as the origin and cause investigator.
And as part of your investigation, did you have the opportunity then to interview Linda Stermer?
Yes.
And do you recall when that interview happened?
I believe January 9th and 10th.
2 days?
2 days.
And why was it 2 days?
We started to do the interview on the 9th. She had appointments. Was supposed to meet with the funeral home and other appointments. So we ended that day and then scheduled on the next day to finish the interview.
So it was kind of just a continuation?
Yes.
And you had contacted Linda then obviously to arrange these interviews?
Yes.
And where did they take place?
The first one was in my work vehicle on the property, and then the second day I believe we sat in her car, or there was a vehicle there. We basically in the vehicle and did the interviews.
And you say driveway of where?
In front of the home.
And did you request that to meet?
The lost location.
Okay, so you wanted to meet her at that location?
Yes.
Did you have any sort of information that from the police officers at that time?
Just the initial investigative stuff, what they had. I believe fire chief was there, talked about their response, the fire call, their suppression activities, pretty much the standard, upfront information to get started.
Was it typical then for you to do interviews in your car?
Yes.
Kind of a common practice?
That was the rolling office.
Were these interviews recorded?
Yes.
And after you recorded them, at some point were they transcribed?
Yes, in our home office.
So who did the transcription? Your home office?
Yeah, it would have been one of our secretaries in the investigative group.
So once they're transcribed, they're reduced to then a written transcript?
Yes.
And then did you check the transcripts against the recording for accuracy?
Yes, always.
That was your common practice?
Yes.
And you did that in this case?
I did.
Pardon me?
I said, the question was who did that?
Oh, I'm sorry. You did that?
Yes.
Okay. And they were accurate compared to the recording?
Yes.
I'm going to show you what's been marked as People's Proposed Exhibit number 6. If you could just kind of leaf through that and tell me if you recognize it.
Yeah, that's a copy of the transcript on our interviews.
And can you just lead through to the back and make sure that there's no alterations or changes?
Yeah, it looks like a full copy.
Your Honor, at this time, I would move to admit People's Exhibit number 6 into evidence.
Object, Your Honor, on the grounds that I don't know what she intends to do with bits and parts of the transcript, but to admit the whole transcript has hearsay in it, has a bunch of irrelevant information in it. So if she wants to read question and answer, we can go ahead and I'll make my objections, but not to admit this transcript total. We're going to go through as she reads it. That was part of my objections to the exhibits.
Do you have specific sections we could talk about?
Yes, Your Honor.
Does someone have an extra copy for me by chance?
Would you like an electronic copy, Your Honor, just real quick, or would you like a hard copy?
We could do electronic copies.
Okay, thank you.
I'll email it to the court right now.
I don't know. Do we approach?
Yeah. Okay, Jerry, the matter we have to address may take a while, so I'm just going to let you go home for the long weekend. And because it's a long weekend, I'm going to just remind you, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction, as well as all of my other instructions, such as not discussing the case with anyone, including family or friends or each other, no research investigations, and enjoy your 3-day weekend. Remember, you don't have to come back until Tuesday, directly to the jury room at 9 o'clock, and wear your badges and try not to lose them over the 3-day weekend. Thank you. And you can leave your binders in your chair. Matters to address, other than what we talked about? You two will make a preliminary. You'll make a preliminary staff. Yeah, or in the conference room, wherever. Okay, yeah, because how about or down in Susan's office? Yeah, if you could at least pick out the areas where if you still agree to disagree, I'll rule on those.
As long as we agree, then we'll black them out, and then if you don't agree, we can just bring it to you. If you want us to send it to you prior, so that you can have.
Yes, that would be great. Thank you. Yep, and with maybe a note of where you're, how far apart you are.
Yes and no.
Yeah, or if there's three, if there's 3 areas of concern, that's one thing. That I have to rule on. If there's 30, just so I can prepare. And then there was this. I thought I toyed with the notion of having that the lay witness come in to testify now, but in light of her test results, I thought.
And I think that was all we all expected.
Yeah.
I don't think that was unexpected results.
Welcome to West Michigan.
I thought what we could do, Your Honor, is I'm going to be switching around some of the witnesses who weren't able to testify that we sent home, shift around some things on April 1st. Maybe we could put Ms. Connie Calhoun on that day on the 1st. And then we have to move Scott Leroy to the 2nd.
Can we do me a favor? Over the weekend, you just email us the start list.
The updated list, yes. Yep.
Thank you.
No problem.
And Jay, would you mind just emailing us a copy of that hard copy?
No, yeah, no problem.
Thanks.
Actually, I'll just, before I forget, I'll just forward you the email I forwarded to the judge, okay? It has it already attached.
Yes. Yeah, so what we can do is we can redact what we agree on, and then any parts that we don't agree on, why don't I highlight with the yellow highlighter, and then that way the court can then just hone in on the highlighted portions. Yeah, and then otherwise if we agree, we can go ahead and black it out.
Well, if you want me to include your assistant on this, or, okay.
We'll get it all.
Got it, my email address.
I have yours, Mr. Kelly. Yes, sir. Yep.